Good morning and welcome to this meeting of the Court Reporters Board. My name is Denise Tagade. I'm the chair of the Court Reporters Board of California. I have a few housekeeping matters to share before I call the meeting to order, beginning with a reminder to everyone that this meeting is being recorded and webcast. Today's meeting will be run in accordance with the Open Meeting Act as required by law. I would ask all of us to please turn our cell phones to silent. You may notice board members accessing their laptops, phones, or other devices during the meeting. They are using these devices solely to access the board meeting materials that are in electronic format. The board welcomes public comment on any item on the agenda, and it is the board's intent to ask for public comment prior to the board taking action on any agenda item. If for some reason I forget to ask for public comment on an agenda item and you wish to speak on that item, please raise your hand and you will be recognized. To better assist the board in accurately transcribing the minutes of the meeting, members of the public who make a public comment may be asked to disclose their name and association. However, a disclosure of that information is not required by law and is purely voluntary. I want to remind all speakers to please stay on topic and keep your comments to 3 minutes or less. If you agree with a prior speaker, please do not repeat the comments, but rather state that you agree with the comments already made. I would like to call the meeting to order and ask Ms. Bruning to please call the roll.
Thank you, Ms. Tagade.
Present.
Thank you, Ms. Dunkeith. Thank you, Ms. Brewer. Present. Thank you, Mr. Dodgenam.
Present.
Thank you, Mr. Manayan.
Present.
Thank you. Quorum reached.
Thank you, Ms. Bruning. Before we invite speakers to begin on agenda item 1, which is public comment for items not on the agenda, ask individuals making comments to not discuss pending complaints, pending applications, or pending disciplinary actions that may come before the board for a decision. Such discussions are considered ex parte communications, as they could provide information to the board members that is outside of the record, which is in violation of the Administrative Procedures Act. Therefore, such discussions could create a conflict and lead to a board decision being challenged in Superior Court. The board can receive comments regarding the board's processes in general, but it cannot receive comments on specific case circumstances where the decision is still pending. The board staff is available to speak with you about any pending matter. In addition, the board would ask that the public address the board as a whole and not individual board members. Please be aware that the public comment during this agenda item should provide information to board members and is not a discussion between the board members and the public. The only action board members can take is to listen to comments and decide whether they want a future agenda item on the topic. No other action can be taken on the item at this meeting. Though this may seem at times like the board members are not being responsive, following these guidelines is critical to ensure the rules of the Open Meeting Act are followed to avoid compromising the speaker's goals or the board's mission. With that, is there anyone wishing to offer public comment?
This is the moderator. I apologize. This is the moderator. I've opened up a public comment on WebEx. Members of the public, if you would like to make a comment for agenda item 1, you can either click the raise hand icon or use the Q&A button down at the bottom right-hand corner of your WebEx screen. If you're an audio-only participant, you may raise your hand by pressing *3 on your device. And it looks like we do have a request from Brianna Lee, Canada. And Brianna, you will be given 3 minutes to speak with a 30-second warning. Please click the unmute me button when the prompt appears on your device.
This is Brianna Lee. I just want to make sure if you can hear me.
Yes, we can hear you.
Thank you. My name is Brianna Lee. I'm a student, a steno student at High Speeds based in Canada, in Toronto. And I wanted to join this meeting to suggest a legislation opportunity, perhaps to amend the NAFTA approved professions to include the court reporting profession to allow Canadian reporters to easily and without financial or time investment from the US employers to allow Canadian reporters to be authorized to work in the States. Currently, there are no ways for Canadians to work in the States, and there is growing interest in Ontario, Alberta, British Columbia, to work in the States, not only to help alleviate the shortage in the US, but also to kind of help revive the unfortunately diminishing demand for stenographers in Canada. Currently, the only way is that the employers in the US will sponsor a Canadian to come over the border, but it does take a lot of time, a lot of paperwork, and some financial investment. And I have attended the CCRA convention in September to kind of propose this idea and talk to a lot of HR people at courthouses as well as court reporting agencies. But because it's not familiar and it takes a lot of investment, unfortunately, nobody was interested in taking on this kind of mission. So I found that if the NAFTA professions are amended to include this profession, Canadians can easily obtain the TN visa, and the employers in the US don't have to make any further time or financial investment than they would if they offered a position to a US candidate. And it will allow for Canadians to work across the border. Unfortunately, in Ontario, where I'm based, a lot of the reporting agencies are using digital reporters, and courthouses are not allowing stenographers back into the courts. But later down the line, I hope that once this legislation may be passed with the strength of CRB and CCRA, we could also help revive some of the associations here in Canada as well. So I hope this can be something you take into consideration.
30 seconds.
Thank you. That's it.
All right, this is the moderator. Appears that was our only request for public comment.
Thank you, moderator. Any public comment in the room? None. Thank you for that public comment. We will take that under consideration. Seeing no further comment, let's move to our next agenda item. Agenda item 2, approval of meeting minutes. That was the July 12, 2024 meeting. Are there any additions or corrections to the minutes from the board members? Ms. Brewer.
Everyone turns their gaze this way. Okay, I just had a few. Let me get my notes here. Page 15 of our packet, 9 of 16 of the minutes. Okay, so I don't know if this bears amending the minutes, and I would look to my colleagues and staff on that. But for this public, I did take my own notes, flawed they may be, but I took notes of the meeting and I consulted them. And one of the things in the first paragraph that Ms. Gaskell said, this says, she stated that proctors try to be, let's see, provided information about their experience, blah, blah, blah. So she said that the proctors were not familiar with the stenomasks, which is, this says did not understand what court reporters or their machines do. And since machines is generally, well, pretty much exclusively in the profession used to refer to the steno machine, I think it would probably be a worthwhile change to add that they were not familiar with the masks as well. Do not understand what court reporters, comma, their machines, comma, or steno masks.
Can we just solve it by calling it equipment?
Yeah, perfect, thank you. Perfect change. Okay, so then the next paragraph, okay, this says Trina Cox commented that the proctors, blah, blah, blah. She was actually speaking on behalf of what her students had told her. That's what my notes reflect. And so I would add, Trina Cox commented that her students have said the proctors tend to be a bit disruptive. And one did not close the microphone, causing the candidates to be more nervous. And also, the proctors on more than one occasion were an hour late. Okay, so that is that section. On to page 17, 11 of 16. This is just an easy little typo-ish mistake. On the third line from the top end of the line, insert the word "the." As long as courts and public know who the court reporter is. And page 19, 13 of 16 of the minutes. Likewise, second paragraph, second line, third after the third word, it should have is, handled since it is not required for the CVR. And then looks like I just have one more. Okay, so on page 20, 14 of 16 of our minutes, third paragraph down, Jean Kim. My notes reflect that she said a CVR applicant without CAT software felt that she could not work. This makes it sound like she's saying they can't. She heard from this person that they did the exam, the CVR, with a recorder only, no CAT software, and when she got out, she felt she couldn't work. And that's it.
Thank you, Ms. Brewer. Appreciate your fastidiousness as always. Other comments, corrections, or additions to the meeting minutes? Looking to the WebEx, seeing none. Okay. Vote then. Public comment? Public comment. Public comment. Do we have a motion to adopt the meeting minutes with Ms. Brewer's additions?
I move to approve as amended the minutes of the July 12th, 24 meeting. 2020.
Great. Motion from Mr. Dodgenam. Do we have a second?
Second.
Thank you, Mr. Manayan. Public comment. Seeing
All right.
none in the room.
This is the moderator. I've opened up public comment on WebEx. If you would like to make a comment on this item, please click the raise hand icon or use the Q&A feature down at the bottom right-hand corner of your WebEx screen. If you're an audio-only participant, you can raise your hand by pressing *3 on your device. All right, and it appears there are no requests for public comment on WebEx.
Great, thank you, moderator. Okay. Renee, would you mind taking the vote?
Yes, thank you, Ms. Brewer.
Aye.
Thank you, Mr. Dodgenam.
Aye.
Thank you, Mr. Manayan.
Aye.
Thank you, Ms. Sunkis. Aye. Thank you, Ms. Tagare.
Aye.
Thank you, motion carries.
Thank you, Ms. Bruning. Turning to our next agenda item, item 3, Department of Consumer Affairs update. I would like to welcome Ms. Yvonne Durantes, Assistant Deputy Director of Board and Bureau Relations from the Department of Consumer Affairs, who will be presenting the board with an update.
Good morning, everyone. Yesterday was my 2 years at DCA, and I don't think I've been at a in-person court reporters board meeting, so I'm really excited to be here, actually. I'm always excited to work with Yvonne, the other Yvonne. I'm so happy to be here. I do have some updates for you, and I'm happy to repeat any of them, but I will say too, this is one of my shortest briefings, so happy Friday to you all. And I think since I haven't had the opportunity to see you all, I wanted to congratulate you as well on your Sunset extension. So thank you for all the hard work that was put into that. I know just how much work goes into that, so thank you for all that. All right, and so I'll jump right in. So starting off with our DEI update, DCA's Diversity, Equity, and Inclusion Steering Committee met last month, and we are excited to announce there are new elected leadership. And so Reggie Varghese, the Medical Board of California's Executive Director, will be serving as our chair, and Marlon McManus of the Board of Behavioral Sciences, Assistant Executive Director, will also be serving as vice chair. And so both Reggie and Marlon have a lot of years of experience and sincere commitment to DEI, and so we are very excited and looking forward to what they will be accomplishing under their leadership. Moving on to the new unconscious bias training for board members. I'm also really excited to share that DCA is currently working on updating its Unveiling Unconscious Bias training to specifically focus on board members due to your critical roles and how unconscious bias can affect decision-making authority. The training will be self-paced and available in DCA's online learning management system, and we anticipate launching this new training in early 2025. Board members will be required to take this annually. And as a reminder, DCA does also offer over 20 online DEI training courses on the learning management system. And while these courses are not required, we do encourage you to take these trainings. And anytime you have any issues with logging in, whether it's just your username or forgot your password, I'm happy to assist with any of that logging in, whether you email member relations, which is usually me behind that email, or whether you email me directly, either is fine. So I'm happy to assist with that. And then moving on to our military licensing resources webinar that's happening this month. To support and maximize outreach to our military community, DCA is hosting a second live webinar on November 21st of this month to share information about military licensing resources. And during the webinar, attendees will learn about licensing resources available to members of the military and their spouses or domestic partners. The webinar will also feature a demonstration of DCA's Federal Professional License Portal and state registration process, which was launched last year in the fall, as well as a Q&A session. So there are a lot more details available on dca.ca.gov/military. And moving on to some logistical items, the new business and travel expense reimbursement program. And so the State Department of Human Resources, also known as CalHR, recently released an updated travel policy to align with federal policies outlined by the U.S. General Services Administration. And so effective October 1st, DCA is using federal standard meals and incidental expense rates for in-state and out-of-state travel. And so DCA will use the federal standard and non-standard reimbursement lodging rates. Information on these changes was shared with board leaders at the end of September, so that should have been distributed in an email. But if you did not receive it or would like for me to forward it again, I'm happy to do that as well. And so board members are encouraged to become familiar with these new travel expense reimbursement amounts and rates. And so, as always, please feel free to ask any questions if you have any follow-up questions in regard to that or if anything's unclear. And moving on to our season of giving, we are officially in November, mid-November officially today. And so we have a couple charitable campaigns that are launching this month. And we did actually just have our third annual turkey drive 2 days ago on the 13th. So that was one of the main efforts. And also every year through the Our Promise California State Employees charitable campaign, state employees, including board members, also do have the opportunity to support a nonprofit of your choice through payroll giving or one-time donations as well. And so these contributions obviously have a really positive impact to our community. And so this year's campaign leads are Monica Vargas, our Deputy Director of Communications, and Karen Navarro, our Assistant Deputy Director of Communications. And this campaign will be launching officially on Monday, the 18th. 31st. And that's all the updates I have for you today. I am happy to answer any questions, or if during break or anything you want to chat with me offline as well, I'm happy to do so. I'm able to pull up your training transcript if you're not sure if there's any trainings that are outstanding for you, especially with December 31st somehow just around the corner. So happy to answer any questions.
Thank you so much, Ms. Dorantes.
Okay, we will now take public comments, seeing no hands raised from the board. Seeing none in the room, moderator, could you open up the public comment?
This is the moderator. We are now open for public comment on WebEx. If you would like to make a comment on this item, you can click the raise hand icon next to your name, or use the Q&A button down at the bottom right-hand corner of your WebEx screen. If you're an audio-only participant, you can raise your hand by pressing *3 on your device. All right, and it appears there are no requests on WebEx for public comment.
Okay, thank you. Thank you, Ms. Dorantes.
Great, thank you.
Great, we will move on to agenda item 4, report of the executive officer. Ms. Fenner, we will turn over to you.
Thank you, Chair Tugade. I'll start off my report with a review of the budget. So on page 25 of the board meeting materials, you'll find the expenditure projections for fiscal month 3. That's our current fiscal year 24-25. It's very early in the budget year, so these are, I would call, very preliminary numbers. We'll monitor them as they go through. Does anyone have any questions on the expenditures? Seeing none, hearing none. Moving on to page 26, you'll see the overall fund condition for the Court Reporters Board. Let's see, on fiscal year 25-26 is when you'll see that we are projecting to start transferring to the transcript reimbursement fund. We're putting $200,000 in at that point. I remind you, I think at every board meeting, it's really difficult to budget for that because we never know how many claims are coming in. So we'll just stay on top of that and monitor it. If you go down to the months in reserve, you can see that in budget year 27-28, we are projecting at 6.4 months in reserve, which puts us really close to our 6 months operating reserve that we need in order to fund the TRF. So I'll be working with our budget analyst as we'll need to keep a close watch on that and our future projections to make sure that we can alert the board in time to take action if a fee increase would be needed. Do we have any questions on the overall fund condition? Being none, I will ask Ms. Bruning to give us an update on the transcript reimbursement fund.
Ms. Fenner, thus far for 24-25, we have paid $55,000 in invoices on the pro bono side. We have paid just over $9,600 this fiscal year for applications approved this fiscal year on the pro per side. But overall, we've paid $19,000. Including previously approved apps from other fiscal years. And we have provisionally approved over $38,000 in applications for provisional pro per applications pending receipt of invoices. We are edging there at the 30-day processing time. And if you have any questions, I'd be happy to take those. Okay, thank you.
We just give kudos to Paula and Elena, who is our staff person that works on the pro per part of the program. They have been really working hard to catch up on our deadline. We got a little bit behind when Elena was off for a little bit on leave, but they've been just working so hard to catch everything up, and I really appreciate all that hard work, and in addition to their other duties. So thank you so much. approval from the TRF for enforcement statistics. So you will see the final report for fiscal year 23-24 starting on page 28 and running through page 32. And then on following those pages, I'm actually close to 30, yeah, you'll find the current stats. So that starts July 1st and they're current through September 30th. Those are on pages 32 to 35. Are there questions on the enforcement statistics? Being none, the results for our license exam begin on page 36 of the board agenda packet. And we start off with the comparison of the steno and the VoiceWriter on the skills portion of the exam, following the regular historical results. So you can see pretty much the trend continues as far as how many voice writers we're getting versus steno writers, and then their success rate versus the steno writers on the passage. Are there any questions overall?
Not a question, but you know, I think it bears repeating over and over again just how exciting that trend is and how incredible just in this short period of time the numbers have been for voice writers. So just so wonderful to see that again. Thank you, Ms. Benner.
I just want to add to that. If you look at the numbers, our pass rate has gone up 50% from this time last year. The numbers are small. I know there's even more coming through the pipeline, but that's a really, really promising trend, as being said, that nearly 50% increase in 1 year. Great.
I do have a question. Do we know how many are registered for the November CSR? How many did register?
I have that next.
Oh, perfect. Thank you.
So the current testing cycle opened on November 1st, and it remains open until November 22nd. We had a total of 172 applications received. Of those, 76 are voice writers, and of the 172, 89 are first timers. First time.
And I apologize, first timers for both methods.
Overall. And
Thank
then
you.
first timer of those 89, 64 are voice writers.
Okay.
Just as an aside, 22 of the applicants qualified using the CVR certification, and 18 of those 22 are first timers.
Thank you.
And then just, I'm adding this on just because everyone's interested in it. We have licensed 103 voice writers to date. Or that's our most recent stat on that. Is there any other questions or comments on the skills portion? If not, Ms. Burke? Oh, sorry.
No apologies. I just wanted to say thank you for this report and thank you to everybody for getting us here. And you anticipated my question, how many voice writers? So I wasn't carrying that in my head, so
Yeah.
Thank you. That's all I wanted to say.
Sure. Yeah, appreciate that you were able to plot all of those numbers. Thank you, Ms. Benner.
Moving on to the written portions, those begin, the English and professional practice are the two written portions, and they appear on pages 38 through 42. And I don't know if anybody had questions on just the written part.
I'm stuck on the 172 applicants for this test. I think that's fabulous. Sorry. Sorry for talking out of turn. Thank you.
I do have just a comment on both the English exam, actually on all of them. I usually go back and I look at our results, and then I go back and see how many years previous was it when we had better results, and we're doing really well. I mean, this is a consistent trend that we're getting more. Really, really nice to see.
And if there are no other questions on the exam, the final portion of my report is on the technology modernization project. So the licensing and renewal portion of the data has been transferred to the new Connect system, and we continue to work out the bugs as they are identified. We hope to continue to refine the processes and move forward with and add the enforcement module. Does anyone have any questions on the technology portion of the report? If there are no other questions, that concludes my report, Madam Chair.
Thank you, Ms. Center. And again, thank you so much to all of our board staff, because, you know, without you, we would not be able to manage all of these new applicants, do all of this work. So again, appreciate all of that. With that, we will move to agenda item 5, legislation. So we will turn back to you, Ms. Fenner. Oh, Ms.
Actually,
yes?
what you just made me think of something, and that is we've gone from about 50 applicants now up to 172 applicants. Is Ms. Kale, does she need help with this? Will we need to think about additional staff to help with that processing?
I don't think so, based on, she comes from back in the day when we had hundreds of in-person applicants. So far she's managing every well. We keep throwing little details at her, like now there are voice readers, now there are different ways to qualify, and of course we want statistics on all of that. So her job is changing, but right now I think that she's handling it very well.
Kudos to Kim.
Definitely.
For sure. Thank you.
Thank you. That's a great point, Mr. Excuse me, Ms. Sunkis. With that, okay, let's move to agenda item 5, legislation.
Okay, on page 43 of the board meeting materials, you'll find the list of the bills that we followed the last legislative session. So the first two, 5.1, 5.2, failed passage and are dead for this legislative cycle. The next bill, 5.3, is AB 3013 by Assembly Person Mainshine, and it was signed by the governor and chaptered, and it establishes a remote court reporting pilot project in 13 counties. It's a 1-year project. Begins, let's see, it will begin, I didn't note it in here. I think it's in January, it goes January to January. I know that it goes through, I think it's January, it might be July to July. I apologize. But it is 1 year, so it is July. Thank you. It'll be an aggressive program to have that up and running in time for it to be effective, as they only have 1 year to evaluate. So hopefully the courts are working hard to have the infrastructure in place so that the reporters may be able to report remotely, and we'll see how it goes. Really excited about this one and hope it goes well.
I do have a question about this. So is there state or any support for the technical aspects that's being provided to these counties, or are they doing it on their own?
I don't know if they have dedicated funds for that or if that's part of the $30 million that they were granted.
Yeah, it would be nice, because as we've brought up in the past, and those of us who are reporters know, that's crucial to this being a success, is having a good platform and good, having everything be audible and et cetera. The parties who are present recognizing that the court reporter is an integral part of the proceedings and is remote.
Yeah, absolutely. Mr. Dodshan.
Following up on Ms. Brewer's comments, do we as a board have any inputs, advice? Is anyone asking for that? Or, obviously we're a licensing board and this is, executed by the courts, but is there any involvement for us in this, or simply are we witnesses at this point?
We don't have any direct involvement. I have worked in the past with members of staff of the Judicial Council who reached out to see if we could help them with like technical guidelines on what they're going to need for the courtrooms.
Okay.
And so obviously I don't have that expertise, but I was able to find a couple of subject matter experts, court reporters basically, that do remote work, and put them in touch with the person from Judicial Council that was trying to wrap their hands around what they're going to need.
Thank you.
Madam Chair, before we jump to 5.2, is it possible for us to just call public comment for item 4?
Yes, absolutely. For item 4?
Yes.
Sure.
Both for comment.
Oh, okay. Would you mind if we conclude conversation on 5.2?
Sure, that's fine. Yeah.
Okay. Other comments from the board on AB 3013 before we switch back to agenda item 4? I was just going to speak to Ms. Brewer's point on kind of some concerns. I definitely want to make sure 1 year is very, very short for a pilot program, just to get that running, to obtain the technology, to obtain the court reporters, to obtain to get that up and running, to get folks on board. And so hopefully if that pilot program is not fully implemented in that year, hopefully it gets continued, because that's it happens. But would love to really see this pilot program through. So hope to see that fully implemented. Yes,
I did have one other comment. I was curious which counties, and so I looked this up, and the material that I found online listed counties, and there were actually 13 of them. Now, I don't know if that is incorrect.
It's 13.
Oh, I thought it said 11. Maybe I misread here.
It does, yeah.
It did say 11, but she did
you said
report
13. I'm sorry, I missed that.
And I believe the mix of counties was specified in order to include rural, large, small, and then ensure that they were able to meet the technological capabilities. But of course, devil's in the details. So yes, Ms. Sankis.
I just hope, I'll just say this for the record, I just hope that, I know there's a lot of public comment about the status of court reporting and the shortage of reporters. I hope that all the stakeholders work together in a positive way to try to make this work. And I'll just leave it at that.
Thank you, Ms. Sankis. And before I will move us back to agenda item 4, apologies, I did not take public comment. And so we will first take public comment on the entire executive officer report, please. Any in the room on agenda item 4? Seeing some in the room. Oh, yes.
Hi, Stacey Gaskill, court reporter. Just a clarification, did you say 103 or 130 voice writers? Or 3? Oh, okay. And then when you go to the website to get a list of the court reporters that are currently licensed, is there a way to distinguish between voice writer and not get a list of just the 103?
Unfortunately, not yet. When we switched over to the new system, that was supposed to be a part of it.
Right.
So right now, they're working on it. We have a ticket in, so it will be fixed. I don't have a date.
Okay, is it possible to get a list today while we're here? Can you guys generate a list? The Court Reporters Board generate a list? Or is it not possible?
Licensing analyst to see what would go into that. Do you know?
I don't know, but I just want to point out that it's one license type. We don't have a distinction between license types.
But we have to note whether it's a voice or steno or both. And so that,
I know it's only captured currently in the comments of what we can see.
right, they have to add a separate field that is what they're working on, they being the IT people for us. It would be very labor intensive because we'd basically have to go in one at a time and look and see.
Okay. All right. Thank you.
Any other public comment in the room on agenda item 4? Seeing none, we'll go to the WebEx.
All right, this is the moderator. We are open for public comment on agenda item 4, report of the executive officer. If you would like to make a comment on this item, please raise your hand or use the Q&A button down at the bottom of your WebEx screen. You may also raise your hand if you're an audio-only participant by pressing *3 on your device. And I do have a couple individuals who have requested public comment. First, I have Dolores Renee Wood, and Dolores, you'll be given 3 minutes to speak with a 30-second warning. Please click the unmute me button when the prompt appears on your device. Oh, apologies, it looks like you muted yourself. 1 second while I request to unmute again.
Can everyone hear me now?
Yes, we can hear you.
Okay, I wanted a comment on AB 3013. Are we still on 4 or should I comment on that now?
We are still on public comment for agenda item 4.
Okay, I can wait.
Okay, if you could lower your hand and then raise it again when we get back to public comment for 5, that would be perfect. Thank you. All right. And then I also have a request from Kari Frasili. And Kari, it looks like you don't have an audio connection. I don't know if you are called in on a cellular device. And if so, can you press *3 on your device to raise your hand? Or if you don't have your audio connected, you can type your comment into the Q&A button down at the bottom of your WebEx screen. All right, unfortunately, I'm not seeing any polling users raising their hand. That might potentially be Kari's audio, and I don't see anything in the Q&A. At this point, would you like me to close public comment for item 4?
Thank you, moderator. And if Kari is able to get back on, we can allow her to comment.
Okay.
Thank you. With that, let's move back to agenda item 5.
If there were no other comments on 5.3, 5.4 is our sunset bill, and that is actually its own separate item coming up next. Do you want me to flow right into the sunset and then take public comment on all 4?
Sure, yes, let's do that.
Okay. On the sunset review, we are thanking and very grateful to Assemblyman Berman and Senator Ashby for authoring this bill for us. It was signed by the governor, chaptered on September 25th. It extends the board until January 1, 2029. And there are a few things of note in addition to the extension that I just wanted to point out for the board and for members of the public. First one is beginning January 1, 2025, CSRs will have to state their full name and license number at the beginning of every proceeding. So if it's an official who's reporting multiple proceedings, they're required to provide their name and license number to the clerk before the first proceeding. Secondly, the term voice writer was added to the list of terms that can be used only by CSRs, by licensees. Third, holders of the CVR or CVRS certificates will not need to take the California Skills Exam. They will have 3 years to pass the 2 written portions, the English and the Professional Practice, in order to obtain their CSR license. Fourth, the percentage required to pass the skills exam was reduced from 97.5 to 95%, again, effective January 1, 2025. And then the last big change to note is that the board will have authority beginning January 1st to request the CSR provide a public email. That's one that the board can share with consumers. So I'm open to questions, comments. I'll start with the board. Any comments, questions? Seeing none. Let's move to public comment. And we are taking public comment on both agenda item 5 and agenda item 6. Yes, Ms. Burr.
I do have a question, but I think it's probably more appropriate to, just because Ms. Fenner, you listed the summary of changes and it included the exam percentage to pass. I have a question and a comment regarding, where is it? Item number 8, the skills exam format change. And perhaps the question is better directed there, but it would have to do with a grading question. And let's see, my brain is a sieve. I had another question that just escaped me. I'll think of it and I'll bring them up there if that's more appropriate.
Okay. Seeing no public comment in the room, then on agenda items 5 and 6, we will turn to WebEx, please.
All right, this is the moderator. If you, for members of the public on WebEx, if you would like to make a comment on this item, you can click the raise hand icon or use the Q&A button down at the bottom of your WebEx screen. If you're an audio only participant, you can raise your hand by pressing *3 on your device. And it looks like we have a couple requests. First, I have Dolores Renee Wood. And Dolores, you'll be given 3 minutes to speak with a 30-second warning. Please click the unmute me button when the prompt appears on your device.
Good morning. Thank you for hearing me. I wanted to comment on both actually now. I was wondering if it would be appropriate as an official court reporter working for the court, if the nameplate with the CSR number on it would be sufficient, or if there is a purpose for actually having the name stated on the record. So that was the one question I had. I could understand for like an official court reporter pro tem to have to state it, but as an employee who's working as an official reporter, that can be extremely cumbersome when you have 175 cases on calendar to constantly be restating it, or if you're just restating or stating your CSR number at the beginning of the proceedings, people are in and out of the courtroom, and it would be difficult, for them to know that you're a CSR. I was also thinking to have the nameplate with your CSR number on it, and then putting the blurb stating your CSR credentials would, in the transcript, I think would even be redundant because it's already on the covers and on the certification page So that's just a comment that I have there. The other thing is, as far as the remote reporting, I love the idea of the remote reporting. While I was working at Riverside Superior Court in the Family Law Division, we only had 5 departments. When we were shorthanded, I would physically walk to all 5 courtrooms to cover them when we had shortages. And so I single-handedly would cover the entire building when we were shorthanded. And I had asked so many times if I could just be in my office and remotely report, because then I can stay in one place and report the whole building. So that was something I had the capability of doing as an official court reporter that was an employee of the court. I had the ability and capability of being able to do that without all the extra technology that would need to be in place. For instance, if an official pro tem came in to do it. So that was something that I really liked hearing. However, I didn't know if it only pertained to the official court reporter pro tems, but I also think the official
30 seconds.
I also think that the official court reporters should be allowed to report remotely, as opposed to what the law states that we personally need to be present where the proceedings are being held. And that's all I have. Thank you.
Thank you, and thank you for your patience with your public comment. Moderator, do we have further public comment?
Yep, we have a couple more. Next,
Thank
I
you.
have Julianne Allen, and Julianne, you'll be given 3 minutes to speak and a 30-second warning. Please click the unmute me button when the prompt appears on your device.
Can anyone hear me?
Yes, we can hear you.
Okay, sorry. I don't have a lot of comment. I just wanted to introduce myself. I'm your assigned legislative analyst. So obviously we're kind of done with everything for the moment, but I just wanted to say hello and I look forward to working with you guys next year. I know I've been in contact with Yvonne by email and such, but hopefully we'll meet in person and I will keep it nice and short. So thank you.
All right, this is the moderator. Next, I have call-in user 4 with the area code 310. And call-in user, you'll be given 3 minutes to speak with a 30-second warning. You're going to press *6 on your device to unmute.
Good morning. My name is Heather Williams. I am a person who is eligible to obtain licensure via reciprocity with CCVR. And my question is, will there be some type of guidance provided, something perhaps on the website in advance of January 2nd, 2025, when we become eligible to apply for licensure? At present, it's unclear exactly how we need to, go about effectuating that process. So I guess my question is, will there be guidance provided, and I suppose also a suggestion that guidance be provided? Thank you.
All right, this is a moderator. Next, I have Anna Fatima Costa. And Anna, you'll be given 3 minutes to speak and a 30-second warning. Please click the unmute me button when the prompt appears on your device.
Good morning. Are y'all able to hear me?
Yes, we can hear you.
Thank you. First, amazing skills results. Thank you. I'll be happy to share with my students. I am a former CSR, 4826. There is no retired designation, otherwise that's what it would say on my account. And I am a teacher at West Valley College of court reporting and captioning. With regard to AB 3013, Is it possible to get the list of the courts that are part of the pilot project? Ms. Brewer mentioned that they're somewhere in the packet. Could you please direct me to that? And that is a wonderful opportunity to be able to cover many courts. As the prior speaker said, she didn't have to walk directly to the courtrooms. She could be present and cover the entire building. So where may I find the list of the courts? Thank you so much.
Anna, I was unclear on your question. Did you want where the board meeting materials are or the language of the bill?
Where I can find the list of the courts that are part of the pilot project for remote reporting.
That's in the bill, the actual language of the bill.
Okay, thank you so much.
Sure.
Okay, this is the moderator. Appears that was our last request for public comment.
Thank you, moderator.
And on one of the other speakers, I apologize, I didn't get the names down, but for the official reporters, if you're reporting multiple proceedings, you just need to give your name and your license number to the clerk. You don't need to state it on the record for each proceeding.
Thank you for that clarification, Ms. Fenner. With that, we will move to a break.
I think we would do regulations. Yeah, we've got 15 minutes.
Okay. All right, let's move on to agenda item 7, regulations. We will move to 7.1. Thank you.
Good morning, Stephen Vong, Regulations Council. I'll start off with item 7.1, Title 16, Section 2420, 2422, and 2473, examination results and transcript format. Again, these regulation sections concern exam requirements, inspection of exams, and minimum transcript format standards, with the package repealing the ability of examinees to request inspection of transcripts due to exam security and updating transcript format standards. The board last approved responses to comments July 2024. Since then, board staff submitted the regulations package to the Office of Administrative Law, OAL, and OAL approved the package on September 11, 2024, and the amended regulations will go into effect January 1st, 2025. The OAL reviewing attorney noted that the regulation package and response to comments was well organized, so special thanks to board staff and to the board members for your thorough review and consideration. No further board action is necessary. Next, we have item 7.2, sections 2401 through 2481 of the California Code of Regulations, called Various Section 100 Proposed Language. Board staff reviewed the board's regulations for potential updates that are non-substantive and do not need to go through the Administrative Procedure Act, or APA, because they do not materially alter any requirement, right, responsibility, condition, prescription, or other regulatory element of any California Code of Regulation provision, such as a repealed statute or grammatical updates. Since then, board staff has submitted this Section 100 package to OAL, and since it doesn't need to go through the APA, no board action is necessary. And OAL's deadline to review is November 26, 2024, and we will update you at the next board meeting on what OAL decides. The next item is 7.3, disciplinary guidelines. This regulation section concerns disciplinary guidelines, which set forth recommended discipline for violations of the board statutes and regulations. It was last updated through OAL in 1989, so a while back. In 2020, the board voted to approve updates, but since then, board staff and legal have re-reviewed and found that it needed substantive updates, such as adding a model order section that administrative law judges use. The text changes to the CCR is agenda item 7.3, attachment 2. Agenda item 7.3, attachment 3 is the old disciplinary guidelines document to be repealed. Staff recommends the board review and approve the draft regulatory language and to instruct staff to proceed with the rulemaking process. A sample motion is in the materials on page 46 of the most recent revised PDF.
Do we have comments from the board, Ms. Brewer?
I just have a couple minor comments. Okay, that's just a comment for myself. Page 64 of our board book, page 16 of the disciplinary and denial guidelines. Under B1, notify employer/firm. The third line, employer or owner of the court reporting firm. I think that should probably be more appropriately any court reporting firm with which respondent is associated, because reporters generally are freelance reporters and they'll work for multiple firms. So instead of the, any is my suggestion. And then the next paragraph under number 1, the second line from the bottom, I think in this instance, it's a court reporter's license. I think it should be apostrophe S for reporters. I said they were minor changes. I have one last one. And this is a question on my part and perhaps a suggestion for a change. And that is on page 70 of our booklet, 22 of the disciplinary and denial guidelines. The very last point, C, petition to revoke probation, revocation of probation. I'm wondering if that wouldn't be aided in for people to understand it with a little punctuation there, maybe a slash or a hyphen or something, or else I'm misunderstanding the title. Seems to me like it should be probation / revocation of probation. Petition to revoke probation / revocation. That's my question / suggestion. And that's it from me. Thank you. And thank you for all of this. You know, like many of the things that we do, obviously a lot of work went into this. And it's appreciated.
Thank you, Ms. Brewer. Do we look to legal? Do we need a motion to?
Yes, we would just say it as amended and the same language essentially. Sorry, Ms. Brewer, can you one more time go through each page and each change? I know they're mostly non-substantive, which is fine, but.
So I'm hoping that you are looking at the same thing that I am, so it makes it easier to find this.
Yes.
Page 16 of the disciplinary and denial guidelines. It's page 64 of our board book. Under B, optional conditions of probation, 1, notify employer / firm. Right under the word firm, 2 lines down, that the should be any, employer or owner of any court reporting firm.
Thank you.
And do you need the others?
Yes, please.
Okay. So if you go down all the way to 2, rehabilitation program, and you go up 2 lines, which a court reporters, that should be apostrophe.
Okay.
You ready for the last one?
Yes.
Okay. Disciplinary and denial guidelines, page 22, page 70 of our board book. That item C at the very bottom of the page, petition to revoke probation, revocation of probation. I'd like to see some punctuation between probation and revocation, unless I'm misunderstanding the intent of this. A hyphen or a slash.
Thank you for catching that. Thank you.
Well, at least you know we're reading these. All that work. You guys are really thanks, and I repeat my thanks for all the work. A lot of work that goes into this.
And Madam Chair, if we want to, we can take care of the the vote for the public comment for the vote, as well as the agenda item itself, if you want to do that one time.
Okay, great. So motion, first, can we take a motion then to adopt as amended? I saw a hand from Mr. Dodge-Nam.
Yep. I move that the board rescind its previous May 21st, 2020 motion and approve the newly proposed regulatory text as amended and changes to the CCR section, section 2472 as provided in the materials, and direct staff to submit all approved text to the Director of the Department of Consumer Affairs and the Business, Consumer Services, and Housing Agencies for review.
Thank you. Do we have a second?
I second the motion.
Thank you, Ms. Sunkey.
I just want to make sure that the second part is included. Yes, you can continue.
We continue with the motion. If no adverse comments are received, authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the package, and send the matter for hearing if requested. If no adverse comments are received during the 45-day comment period and no hearing is requested, authorize the executive officer to take all steps necessary to complete the rulemaking and adopt the proposed regulations for Section 2472 as noticed.
Thank you, Mr. Dodge. I appreciate that. Thank you, Mr. Bowles. And we have the second from Ms. Sunkey.
From the full motion.
Wonderful, wonderful. And do we have public comment in the room? Seeing none, do we have public comment on WebEx?
This is the moderator, and we are open for public comment on WebEx. If you would like to make a comment on this item, please click the raise hand icon or use the Q&A button down at the bottom right-hand corner of your WebEx screen. If you're an audio-only participant, you can raise your hand by pressing *3 on your device. All right, and seeing no requests for public comment, would you like me to close that Q&A panel?
Yes, thank you, moderator. And before we turn to a vote, I just want to thank Mr. Vong and Ms. Figueres again for all of the just astounding and really thorough work here. So appreciate that again. With that, we'll turn to Ms. Bruning.
Thank you, Ms. Brewer.
Aye.
Thank you, Mr. Dodge-Nam.
Aye.
Thank you, Mr. Manayan.
Aye.
Thank you, Ms. Sunkey.
Aye.
Thank you, Mr. Gade.
Aye.
Thank you. Motion carries.
Thank you. With that, I believe we will break for 15 minutes. So we will be back at 10:25. All right, we will call this meeting of the Court Reporters Board back into order. I see we have a quorum again. Do we need to call roll again?
Sure. Mr. Gade.
Present.
Ms. Sunkey.
Present.
Ms. Brewer.
Present.
Mr. Dodge-Nam.
Present.
Mr. Manayan.
Present.
Thank you. Quorum reached.
Thank you, Ms. Bruning. Let's move on to our next agenda item item 8.
Thank you, Chair Tugade. At the April meeting, the board voted to change the format of the skills exam from the 4-voice for 15 minutes at 200 words per minute to the universal format of 3 5-minute tests, one at 180 words per minute for literary, one at 200 words per minute for jury charge, and one at 225 words per minute for 2-voice testimony. We are going to need some subject matter experts to write these exams. Staff obviously can assist in the final word counts, the pre-testing, recording the tests, but we're going to need assistance with the creation of the actual exams. We're recommending that a task force might be the best way to achieve that. Additionally, the board is going to need to decide if the 3 tests can be passed over a period of time or if they need to be passed in one sitting. So for board reference, then the national certifications, you can hold over any portion that you pass, sort of like what we do with our 3-part license exam. If you can pass the English, then you can wait and pass the professional practice and the skills. You don't have to do it all in one sitting. In fact, you can't, because they're all online. So that would be a decision the board will have to make, and I'll turn it back to you.
Thank you, Ms. Fenner. Do we have any board members wishing to make a comment, Ms. Brewer?
So I do have some comments as to how long one has to pass the test, holding over legs that you've already passed. NCRA, it's my understanding, for the RPR allows 3 years, and the NVRA allows an undetermined amount of time. They just say, good, if you've passed, you've passed, and you can pass the other legs at a later time and become certified. So just wanted to point that out. I don't know. It seems to me like I've looked at our guidelines and we have a time limit within which people currently can.
3 years. Okay, so 3 years. So we're talking, I'm sorry if I missed it. Are we talking about the recommendation being 3 years? There was no recommendation. Okay. On our overall license exam, it's 3 years to pass those 3 portions. Okay. Now, one portion is going to have 3 additional sub-portions. That's, I think, where the subparts and the 3 are getting confused. Right. So the overall exam, 1 skills test, 2 written, you have 3 years to complete all 3 portions. Now we're focusing just on the first part, the skills portion, which now will have 3 portions in and of itself. Do you want those to be passed in one sitting, or can they carry those over for 1 year, 2 years, 3 years, whatever the board's pleasure is? Okay, thank you. So I have more on this matter. So, okay, so my understanding still of the relevant national tests that we are going to be comparable to is that the RPR, it's 3 years for skills, and that for the CVR, there's no time limit. So personally, I'd like to see the 3 years. I think it's reasonable, and you know, skills can go stale. Certainly, if they're not licensed, the skills can go stale. So I would like to see the 3-year limit. And then secondly, leading up to this whole issue, it caused me to review our grading guidelines and the test writing guidelines. And I have written the RPR. My only experience with only relevant test is with the RPR and the registered merit reporter, which is not relevant here. It's a higher speed level for the non-licensing members. And our grading guidelines, which are intended, written, I think, with our 4-voice testimony, longer test in mind, are different from the RPR and are different from the CVR. And with going to the 95, they're more generous in some ways, and they're more stringent in other ways. Most noticeably, speaker identifications are weighted more heavily for errors and more lenient in that if somebody misspells something repeatedly or has a wrong name repeatedly throughout the test, they're only marked off for the first occurrence. And in the RPR, and my understanding is in the CVR, that is not the case. It's each occurrence of that error. So I would support moving more towards the already accepted national guidelines, particularly since we're going to 95%. Those tests, yes, are 95%, but in some instances, what would be counted as 1 error on our current exam would be potentially multiple errors on those exams. So, and you know, the reporters, they are doing this generally, or the students, on computer, and my understanding is that they can use their spell check. They've got a dictionary. I mean, they've got the tools, and that's part of the job. You know, if somebody opens the transcript at a certain page,
they don't know that it was marked off as an error on page 5, but every time it's misspelled later. And it can be pretty startling. I mean, I've gotten transcripts from previous reporters where they have parties' names misspelled. And I think, am I wrong? Is the caption wrong? What's happening here? So anyway, that's way too much information, but I would be in favor of 3 years, and I would be in favor of bringing our guiding, our grading guidelines closer in alignment with the RPR and CVR. And I did print for any of our for anyone who's interested, I have a copy of NCRA's guidelines for grading, which is called What is an Error? And the CVR has a lovely entire booklet on their exams, which includes, it's easily found, that includes like a 8-page grading policy sheet. So, and then I also have, which I have provided to Ms. Sunkeys at some point, a comparison that I did for another committee of different what is an error sheets. It's way too much detail, but if people are interested, those are available. Thank you.
Mr. Dodgenham, did you have a?
Well, I just had a point of order. I just want to clarify. One is I'd love to see a copy of that, but point of order, just want to clarify what we're trying to decide at this point is, just want to clarify, I think we've already agreed as a board on changing the skills format, but are we right now, we're trying to determine we're going to give a time period such as 3 years, as Ms. Brewer suggested. Are we also trying to assign a task force, or right now we just focused on 3 years? Question to the chair.
We can take a motion on to determine the time frame. Mm-hmm. I imagine this is the chair's preference that we may need more discussion on how exactly we're aligning the guidelines on grading, but definitely concur with Ms. Brewer's comments and appreciate all of that work, and would love if it's appropriate perhaps to ask you to participate in a task force, and perhaps enter your work into that record for that. That would be so helpful. Yes, Ms. Brewer.
Oh, I'm sorry. I was just going to suggest that, and then the task force could come back to the board with recommendations as on the grading plans. The grading policy, as well as how to get the tests written at the universal format, et cetera.
So this is the reward for having an opinion.
That's right. Exactly.
You did the homework already, Mr.
No, I'd be happy to serve, but I would just want to point out that my term expires in May. So we might want to be thinking about having some continuity going forward, or perhaps the task force could, depending on the charges to the task force, perhaps we could accomplish those things by then. That is 6 months.
I am glad to, by the way, I'm glad to help with the task force.
Excellent.
Yeah.
Thank you.
Thank you very much. Wonderful.
Out there by
Which
yourself.
I know this is probably out of order, but I want to say that Ms. Sunkeys and I worked on the best practices pointer task force, and it has been wonderful working with her, as well as our staff and the public. So
fantastic.
Total aside.
Well, I appreciate our court reporter members of the board for taking on this task. So we'll look forward to that.
So just
go ahead.
I was just going to clarify that the chair has appointed Laura Brewer as the task force chair that is going to be taking on looking at the grading policies and aligning them with national, as well as developing the skills portion of the new format exam. And Ms. Sunkeys has offered to be on that task force. That's at the chair's pleasure. That's done. we would just need a motion then on the pleasure of the board on if they accept Ms. Brewer's 3-year recommendation on passing the 3 parts of the skills exam.
A motion for Mr. Dodgenam?
Sure. I motion that this staff recommends that the board allow candidates to pass the 3 portions of the skill test over the same 3 years that they must pass the entire exam.
Second that motion.
Okay, a second from Ms. Unkees. Do we have any other comment from the board? Seeing none. Public comment.
Hi, my name is Heather Lynn Gonzalez, CSR 13646. I have been very, very involved in the development of the tests that we currently have with the Office of Professional Examination. I'm one of the readers for the tests, did that both online, then we switched to remote, came up and spent a lot of distance time trying to read in time. I would be very interested in helping in any way possible with any of the work that you need to do to create new tests. From the beginning of my career, I was working at my college helping update old tests to make so that we didn't have a house being sold in Beverly Hills for $20,000. But things like that. And so I am willing to make myself as available as humanly possible to the task force to be able to help with that, help with timing, help with all of those different things, subject matter, all of that type of stuff. I've taken both the full RPR as well as the CSR and am here to help in any way possible. I also really like the idea of it being 3 years, because the idea of having to take 5 tests in a very short period of time and pass all of them is terrifying. So my opinion on that is 3 years would be fantastic. Thank you.
Thank you. I would just like to thank you, Ms. Gonzalez, for your past help with the board. You've always been very supportive with our testing efforts, and we will really appreciate taking advantage of your time, which I know as a working reporter is really valuable. So thank you so much for that.
It's important to get new people out, so I appreciate, and I want to help in any way I can. Thank you.
Good morning. My name is Michelle Caldwell. I'm the president of the California Court Reporters Association. We also just wanted to express our interest in being part of that task force and having a seat at that table, whether that's me personally or one of our appointed board members. We would like a seat at that task force table. Thank you very much.
We appreciate the support of your association. Thank you very much. Seeing no further public comment in the room, can we turn to WebEx, please?
All right, this is the moderator. We are open for public comment on WebEx. If you would like to make a comment on this item, you can raise your hand or press the Q&A button down at the bottom of your WebEx screen. If you're an audio-only participant, you can raise your hand by pressing *3 on your device. And it looks like I do have a request from Stephanie Leslie. Stephanie, you'll be given 3 minutes to speak and a 30-second warning. Please click the Unmute Me button when the prompt appears on your device.
I'm the president of the DRA currently, and we would also love to get a seat at the task force if possible and have a voice in that. I'm very excited about the changes. I know not everyone is, but I do think it will grant a lot of reciprocity and different options to solve a lot of our problems as an industry. I also wanted to, I think I know the answer to this question, but I wanted to just clarify, since there are a lot of moving parts currently that are similar. I just wanted to clarify that starting January 1 of 2025, the percentage rate to pass the test is going down to 95%, but in our current format. And I'll ask correct, but I know you don't have to answer my questions. And that this potential task force for changing the format of the test is obviously a longer term process, but that some changes are going to be implemented January 1st, and this particular one is, going to take some time. So I just wanted, there's some confusion sometimes among our members. So I just wanted to maybe ask you to clarify that and so it's crystal clear. But otherwise, I have no comments. Thank you so much.
All right, this is the moderator. Our next request for public comment is Dolores Renee Wood. And Dolores, you'll be given 3 minutes to speak and a 30-second warning. Please click the unmute me button when the prompt appears on your device.
Hello, I just wanted to echo the support of everyone. I also would like to help with the task force if possible. So that's it.
All right, this is the moderator. It appears there are no further requests for public comment on WebEx.
Thank you so much, and appreciate all of the support and the time being volunteered. Again, I'll echo our executive officer that we know that time is valuable, so appreciate that. I wanted to go back to Ms. Leslie's question regarding when that 95% threshold is going into place. That is January 1, 2025, and that's correct in our current form of the test because that was in our sunset bill. With that, is there a good place for folks to reach out if they would like to be involved in the task force?
The best would be to contact staff. It's our first name dot last name at dca.ca.gov. So Paula Bruning's name is on the agenda. I think my name's on the agenda. Those would be the two obvious choices. Or just give us a call, and we're really happy to have you join the task force.
Excellent. Great. With that, let's move on to agenda item. Oh, we need to vote. Thank you, Ms. Bruning.
Thank you, Mr.
Aye.
Thank you, Mr. Dodgenham.
Aye.
Thank you, Mr. Manayan.
Aye.
Thank you. Ms. Sunkees?
Aye.
Thank you, Mr. Gade.
Aye.
Thank you, motion carries.
Thank you, Ms. Bruning. With that, now let's move to agenda item 9, the skills exam reciprocity with the RPR.
So as you know, we began exploring reciprocity with the RPR several years ago, including hiring the Office of Professional Examination Services, which is our sister agency in DCA, to perform an evaluation of the test. In 2021, OPS reported back to the board about a deficiency in the occupational analysis associated with the RPR, and the board decided to defer reciprocity until that deficiency could be cured. So I have heard from staff at NCRA, they let us know that they're working on an updated occupational analysis, and they hope to have it completed early next year.
Thank you.
We look forward to having that issue before the board again next year.
Thank you, Ms. Fenner. Any board comments or questions? Ms. Brewer.
Yes, I do have a comment, and I'm sorry for my ignorance or forgetfulness, whichever. So when the board previously discussed this reciprocity, and it was determined that the occupational analysis that NCRA has was insufficient, inadequate, whatever, deficient in some way, was that for the entirety of the RPR? That was only skills.
Correct.
So now we are considering only skills.
Correct.
Okay. So, okay. Thank you.
Thank you. Other questions or comments from the board? Okay. Seeing none. Public comment in the room. Oh, Ms. Brewer?
I'm sorry.
Oh, sure.
I do have one last question. So when should we're just waiting right now for their OA, for the NCRA's new occupational analysis, or what's the next step absent that updated occupational analysis? Are we able to consider and accept skills absent that updated occupational analysis? In other words, did the occupational analysis deficiencies relate to the entirety of the test, skills, and written knowledge, or was it just the written knowledge?
It was particular to the skills portion.
Okay.
That's where the deficiency was.
Okay.
As far as your question on process, once that's available, the new occupational analysis is available, I would recommend that we reach back out to OPES and see if they can do, hopefully not a full evaluation because they're quite expensive and time consuming. So I'm hoping that they will have the background from having gone through it before, but I'll reach out to them and find out their timing and how much it would cost for us to do that. The board would approve. Once we get the result of their findings, then at that point you would be ready to make a decision whether you want to do the reciprocity.
And I would request, just like you all on staff are just looking for things to do, I know, but if there's any legwork that can be done ahead of time to see if there is an expedited or abbreviated approval process for OPES, given that they went through all of this exhaustively and knew what the deficiencies were, if we could kind of get that lined up so that when we get the OA, we can hopefully get a quicker decision.
Yeah, the good news is the information that I'm receiving from NCRA is being copied directly to the contact with OPES, so they're aware. That doesn't make their staffing issues any easier, so I will take that to heart and make sure I reach out right away. And if we need contracts, make sure that those are in place, because that also slows things down.
Right. And also, I imagine, because you're so efficient and so on top of it, that they know we have a dire shortage that has gotten significant attention from the legislature. So, you know, whatever pressure, whatever positive pressure can be put to bear would be great.
Yeah, the sooner that we can, as a board, agree that that test is adequate for reciprocity, we'll still have to go through either a legislative process to amend 3252 to include the RPR, or try to do it through regulation, which just takes forever. So there will be steps to take after the board decision. So yeah, we want to move on all of that as quickly as we can.
Right. Well, perhaps we could find some friendly legislators who were on the sunset review, because they're obviously concerned about this. So anyway, thank you. I know you're on top of it.
Yeah, Ms. Brewer, other questions, comments from the board? Seeing none, we'll turn to public comment. Seeing none in the room, could we open up public comment on WebEx, please?
This is the moderator. We are open for public comment on WebEx. If you would like to make a comment on this item, you can raise your hand or press the Q&A button down at the bottom right-hand corner of your WebEx screen. If you're an audio-only participant, you can raise your hand by pressing *3 on your device. All right, and it appears there are no requests on WebEx for public comment.
Thank you, moderator. With that, let's move to agenda item 10, expanding the court reporter training programs and recruitment as a part of our strategic plan. Ms. Fenner, I understand you have a couple of items board staff has received, which you'd like to share.
Yes, so this summer the board did receive a letter from the chair of the Assembly Committee on Judiciary offering to help the board work with California's community colleges to study how best to increase the availability of court reporter training programs. So since that's part of our strategic plan, I wanted just to point out that that offer has been made to the board. Additionally, you heard from the court reporting student from Toronto this morning who approached us with trying to amend the NAFTA approved list of professions to include. So those are two things. And then just this week, we received an email from Department of Rehabilitation asking if we could meet and see what kind of energy we could generate from that, so that we could, they could help us with our shortage. We could help them with the training, so to speak. don't have any details on that, but we are, thanks to Paula, setting up a meeting for next week. Sorry to throw the surprise one in there for you.
Excellent. I saw a hand from Ms. Sunkeys. Did you want to?
Oh, I was just going to add that the reporter from the reporting student, high-speed reporting student from Canada, I remember her speaking at the CCRA convention that I did attend, and she was talking about the ramifications of NAFTA and possibly getting that expanded to include court reporting. And I'd like to see that on a future agenda, if there's anything we can do in that regard to work on that. Especially, it sounds like it's not just her. There's interest, and if they've got digital in their courts, that means they've got their students are looking for work, and so I think that's a win-win.
And I would add that, you know, NAFTA is a two-way, three-way, I guess, three-way, perhaps more, agreement. And so it would facilitate United States reporters working in Canada. And I have worked in Canada, and it was difficult. My client had to intervene in order for me to get up there and work. So, and that was covering meetings. But it would be very nice if that were facilitated. It would be nice all around.
Thank you for that perspective.
Do we need a point of order? Do we need a motion to request that, or are we just fine informally?
Before, I have just a few thoughts on that.
Oh, yes, Mr. Ryan.
I think there's great concerns. I mean, great points raised. But as part of that, if this is going to be agendized for a future meeting for discussion, I'd like some background as to the current needs, right? The demand in California, and making sure that we don't do anything that hurts our licensees in California. So as part of that discussion, if we can get some background information there, that would be great.
And Mr. Manayan, are you speaking in terms of supply of court reporters, or maybe if we can drill in on so we can direct staff a little bit?
Yes. So supply of court reporters, the demand here for additional court reporters from abroad. I just want to make sure that we prioritize, make sure that we're looking out after our licensees here, make sure they have the opportunities before we look to expand to foreign licensees.
Thank you. Mr. Dodgen?
I just want to comment that one is I want to make two comments. One is I think it's stated that we have it is a clear assumption of this board that we have a severe shortage currently, which we have been addressing over the last several years, and we are seeing trends improve. But I think we can state that there continues to be a severe shortage of supply of reporters here in California. And second, I want to state just, I think we all know this, the health and well-being of our court reporters is incredibly important, but our first and foremost duty is to the people of California to make sure that they are getting the supply of services that are required. And so we should explore every way possible to provide that. Of course, that does not detriment our current supply, because that would hurt the consumer in the long term, but our responsibility is to the consumer.
Correct. That's part of that. And just to echo
I will add that.
Sorry, go ahead, please.
Go ahead.
Mr. Manayan?
Yes, I was just saying we should certainly be looking at that as well. Just want to make sure we have the data to go off of.
Thank you, Mr. Manayan. Ms. Sunkeys?
I can tell you that every one of the 58 courts in this state need has is hiring.
And can't fill the position.
Exactly. They're hiring, there are hiring incentives, there are finder's fees, there are retention, yeah. So I could tell you that.
Ms. Brewer?
Yes, I have a question for Ms. Fenner. Now, currently, there's no restriction on a Canadian citizen taking our test, correct? Or is there?
As long as they qualify,
Right, as
Yeah.
long as they're qualified like any other candidate, the fact that they're from Canada would not preclude their taking our test.
correct.
And number two, my understanding is that they could work remotely currently from Canada covering deposition freelance work. Is that correct?
I don't know if that would violate visa laws. That's a
Oh,
federal
that might
thing.
violate visa laws. Okay. Okay, thank you. Yeah, okay, I hadn't thought about it from that perspective. Okay.
From the Court Reporters Board point of view, if you have a California license, we don't care where you're working from.
Anywhere in the world.
But with the visa issue between countries, the federal government might have a dog in that fight.
Okay, thank you.
Thank you for that clarification, Ms. Fenner. To direct the conversation a little bit, as Ms. Fenner noted, we have this really generous offer from Chair Kalra from the Assembly Judiciary Committee. I think this is an incredible opportunity to perhaps partner on maybe an informational hearing or some other sort of way to really bring again more positive attention to the efforts that we're doing here to really reach out to some of the partners that we haven't worked with before. I know I've raised in these meetings before starting to work with workforce development boards more with recruitment. I'm really excited. I had not had the thought to reach out to the Department of Rehabilitation, but that makes a lot of sense. So thrilled that we're getting a meeting together with them. And I know we've spoken about the community colleges, but we haven't thought about maybe Calbright as an option, given that so many of our programs are online anyway. And so I just think there are so many opportunities. So would love to kind of think about what can we bring to a conversation with Chair Kalra from this board on kind of what our proposals might be.
You're opening
the conversation.
As far as asks to how
asks, and then what are we going to bring? Like what would we like out of that? Suggestions. I know we were also requested during the Sunset Review to start reaching out to school boards and local education agencies to kind of start like early recruitment potentially.
I see adult schools like Poway Adult School in San Diego County has a court reporting program. I know that Vista Adult School is trying to form a program. If there's, and I don't know if this is the chancellor's office or if help can be, we could start with the assembly representation to how to develop those. Because if we could do that in more locations up and down, I'm sorry, I'm using my hands, up and down the state is what I was trying to represent. If we could get those programs at the adult schools, that would be a fabulous resource. Those programs are basically, they're not for profit, and so makes them very attractive. That's one thought.
I have a question. Is the stated goal to, I guess, can we take a step back and see what the ultimate goal here is? Is it to increase awareness, get more applicants? What are we ultimately trying to achieve? And is there a metric that we're trying to target?
Thank you, Mr. Manine. I think if I don't have the letter right in front of me, but generally the goal is to increase the supply of court reporters in California, and access for consumers.
And they were taking it from the point of view of, do we need more training programs? If we need more training programs in order to train the people that we're recruiting, then they could help us with the chancellor's office with, trying to work on ways to get those additional programs ready. That's the point of view they took it from. The letter was quite broad. I'm sure they would be open to any help they can give us if we have any specific ways to target them. As Member Sunke's pointed out, perhaps the adult schools would be more productive than going into the community colleges. I know we have current programs in both, but that's a good thing. That's good information that we can take back to Assemblyman Kalra.
Ms. Sunke?
One other thought that I had is when we were discussing this during strategic planning back in August last year, I know that just coincidentally, the governor was on TV announcing an emphasis being put on adult education or vocational training. And some funding is my recollection being available for that. So that might be another important piece of information to take.
Funding?
Yes. Well, yeah. Well, maybe it will. Maybe how things change in a few months.
But absolutely, and that would be through like Department of Labor and or the Labor and Workforce Development Agency and again Workforce Development Board. So yeah, absolutely. I think that's absolutely in line with our charge and with what the governor is seeking to do. Mr. Dodgen?
As I kind of read this, and I haven't read the letter, but as here we see the judiciary plan to develop a plan to increase the availability of court reporting training programs. I kind of break it up into three areas and see if you guys agree. One is just overall awareness. We're generating greater awareness of the existing programs so that, that creates availability. The second is access, and that's where it comes in both of the funding, as you talked about here, and also just helping people in the application process or applying and being aware. And there are probably other aspects of access. And then the third would be if those two are not sufficient, then the supply or the number of training programs. So I think all three of those probably need to be explored and addressed to try and figure out how to increase the overall availability. That was my comment. And then the question is, I just want to try and understand what is before us now. Are we trying to solve some of this currently as a board and come up with ideas, or are we just trying to identify resources from this board to go explore that? I don't know, kind of as a point.
Do you want to speak to that, Ms. Fenner? Or
I think I'm probably going to say the same thing you are. We're taking a few minutes to brainstorm a little bit. You'll want to prioritize what you want to do, and then if you're going to direct staff to set meetings up or do research or whatever, or if you need board member leading subtask forces or being assigned to different pieces of that. And I apologize if that's what you were going to say, Mr. Gotti.
Oh, no, that sums it up.
I have a follow-up question.
Yes, Mr. Dodgen.
And I apologize, I should know this and don't. Question for Ms. Fenner is, what is the current level of staff involvement in this? Because this is something obviously we talk to the schools, we do lots of awareness building stuff. So maybe understanding a little bit of what are the current resources and time commitment of the staff to then see if we need to devote more time and more resources.
So currently the board keeps track of schools to ensure that they are teaching the curriculum that we have developed and set out. Those are largely paper reviews. Back in the day, before COVID, we used to actually go on site and basically make sure that the paper matched what was mailed into us, you know, that what, I had one of the subject matter experts that came with us say, we just want to make sure the paper can walk. So it's just making sure, getting hands-on feel. We interviewed students when we would go out. Part of it is COVID, part of it is financial, that we don't go and do that now, and rely on the paper review.
Okay.
So that's not as time-consuming for staff resources. We have very limited staff resources. We can always rearrange what we need to do. So I don't want that to be the limiting factor.
Sure.
Hopefully that helps.
Okay.
But yeah, we would want board member participation, I think, to maximize this effort.
And so to be clear, I think next steps, once we kind of have a set of general ideas, and this is not up for a vote. This is really just to get a sense of what the board would be interested in prioritizing. We'll plan to reach out to Assemblymember Culver's office and follow up on that letter in the interim, and see how exactly we'll move forward. Like I said, an informational hearing is pretty common, but you know, there's many ways to kind of engage here.
I'd like to volunteer on
and
any.
you know, I'll
Sorry, please go ahead. It's a little bit of a delay on my end.
Thank you, Mr. Manayan.
Can you guys hear me?
Yes, thank you, Mr.
Oh, okay.
Manayan.
I'd like to just volunteer on any brainstorming committee or subgroup that's formed, just to help materialize some of these great ideas we have and try to create action items. I know I've spoken with a number of legislators, school board members on a local, state level, and there's great interest. Just want to help make sure we put these items, act on them. So happy to help any way I can.
Thank you. And I will say, because this is such a priority of the board, I would actually suggest that we don't create a task force, but instead, you know, have all of our board members participate as they, you know, are able to. And I would love to have you, Mr. Manayan, you know, involved, and really all of our board members, you know, as you're able. Thank you.
I would just point out that in any particular initiative that we take on, that we can't have more than 2 board members at a meeting, because then we do have to notice that as a public meeting, because when we move to 3, we have a quorum. So just we'll assign out pieces, basically, I think, in 1s and 2s, if that makes sense.
Thank you. Thank you for that reminder and clarification, Ms. Fenner. Of course, always in line with Bagley-Keene. To jump back, I really like Mr. Dodgenam's suggestion of breaking out this conversation into those 3 parts of awareness, access, and then programs. I know, Ms. Fenner, you've spoken with some of the programs. I don't know if you'd be able to speak to kind of what that availability has been like, especially with all the voice writers coming in.
So I think a place that the board could be of service, I spoke with Mr. Dodgenam a little bit about it. We touched on it lightly. There needs to be information out overall to the consumer on, you can pick it on voice writing, you can expand it to overall court reporting as a profession. There could be several different campaigns, if you will, that would come out of one initiative. So as part of our pro rata, we do have access to help from the Department of Consumer Affairs, specifically their public affairs office. So we can get help in producing those pieces and writing those pieces. So maybe as a part of that, then I see a happy hand over here. Maybe, Mr. Dodgenam, we could put you in charge of that. I can work with you. We can set those meetings up. And so we can get specific focus going on that overall awareness campaign, not just for voice writing, although that's the newest and probably the most in need to get that information out, but then we would just generally recruit for the industry overall.
And that's specifically for prospective court reporters.
General awareness. It can be used to the public as far as most people have never heard of court reporter. And that's a good thing. That means they're not involved in the legal process in any way whatsoever. But it's an amazingly lucrative field, open to so many people. There are so few limitations that we can just help to get the word out to the public in general, and then out to students who are looking for a way to have a meaningful career.
The recruitment tagline is the best profession you've never heard of.
Mm-hmm. And then speaking to the number of seats available in programs, I know, Ms. Fenner, you've spoken to kind of the wait lists. Would you have a little more to share on that?
I don't have the specific numbers. I know that some of the associations have been working with the schools on getting that specific data. The Deposition Reporters Association has, I think, tried to stay on top of their numbers. They spent some time last year really focusing on each of the schools and what their enrollments were like, that type of information. And once you get that information, it makes sense to keep it updated. So I can reach out to them to see as a starting point, and maybe share the load of updating that information, because it's time consuming to reach out to the different programs. And the programs are understaffed as we are, and so trying to have the teachers find time to answer the questions, it just takes some time. So we can work on that piece of it as well, the statistical information.
I can tell you that at least one of the courts, one at large court, has started a program for its current employees to go to court reporting school. And so and I think there are other courts that are following it on that path. And so the schools the programs that I'm aware of have wait lists because they are only modeled to be able to teach so many students. And of course, it's all online, so that makes it the access easy, but we need more programs for sure. That would be very helpful to the number of licensees eventually.
So for the purposes of this discussion, can we then assume that although we don't have specific data from each of the schools about their wait list or their capacity, we can make, was it safe to make the assumption that there is a shortage of teaching opportunities, and that is another area that this effort should pursue, is increasing either through adult education or vocation, number of slots.
What a nice segue into the third slide.
I will also jump back to that access question. I think that we still have a black box that we don't have insight into, and I know we started to attempt to address this in our sunset review on some of the diversity, equity, inclusion questions that we just don't have insight into. I know we had looked at how we could collect that data. I know we're working on, with tech modernization, being able to really use data more. But I wonder if, is that something maybe we could explore, whether that's with Assemblymember Kalra, if that's a legislative fix, or if that's something we can do, the regulations, to be able to have that data. I think that, I know that anecdotally we talk about how diverse the workforce is. I would love to be able to see that. And I think until we actually see that data, I don't know that we don't know what we don't know. And so would love to be able to really see the actual spread of it.
Are you talking current workforce?
Current workforce.
Yeah. Okay.
And, I think I've brought this up in meetings in the past, but nearly all of the other licensing boards, nursing, what have you, they all collect demographic data. So, sexual orientation, gender identity, race, ethnicity, language spoken, if there's, languages other than English, these key demographics that might matter for, what kind of service that they're providing to consumers. And that might also matter for like who's getting recruited into these programs and who's making it through programs. Ms. Brewer.
So perhaps this has been mentioned before, but wouldn't it be possible with the online renewal now that we could add even a voluntary demographic data?
It would have to be voluntary
Yes,
because we don't have the legislative authority to require it, but certainly we could add something voluntary.
Yeah, and maybe with a little explanation that in an effort to increase our outreach
To target our recruitment.
it would be helpful to have this information.
And to that point, I think it will always be it is always self-reported, it is always voluntary. And, there is always an option that says, prefer not to respond or, something to that effect. And so, but I think that that's a really important first step in us understanding our workforce and where, like I said, we have this lack of insight. Yes, Mr. Dodgenham.
I think that's really helpful, and that gives a good practical use for something we've been talking about a long time. So I think that we should pursue that. Another aspect of access is for current potential students is the funding piece or whatnot. And again, we don't have the ability to provide funding or scholarship, but I'm wondering if this might be part of the exploration with the the assembly chair, to pursue something of that, or whether there's matching funds or something that would incentivize schools to provide scholarships with matching funds, or some other program by which to incentivize folks to go into this for education. So.
Ms. Brewer?
With that piece, I'm wondering if that wouldn't be a good focus with the Department of Rehab.
Mm-hmm. Yep. Mm-hmm. Absolutely. Yeah. So someone's got to explain because they have the funding, right? And they're just probably not focused on our particular profession. That could be access.
Yeah, absolutely. And like Ms. Sunke's mentioned, the governor's focus on vocational training and CTE is really aligned with these efforts. So I think even in this climate, there's definitely an interest. With that, any other questions, comments from the board? I think maybe we've come to kind of a good pausing place for now. And I'll be excited to reach out to you all as we move forward. And with that, we will take public comment on agenda item 10. In the room, seeing none, on WebEx, please.
All right, this is the moderator, and we are open for public comment on WebEx. If you would like to make a comment, you can click the raise hand icon or use the Q&A button down at the bottom right-hand corner of your WebEx screen. If you're an audio-only participant, you can raise your hand by pressing *3 on your device. All right, and it looks like we have a couple requests. First, I have calling user 15 with area code 310. You'll be given 3 minutes to speak and a 30-second warning. You're gonna press *6 on your device to unmute yourself.
Hello, this is Heather Williams. I really enjoyed this conversation about sort of the next steps, and I just wanted to mention, in terms of getting the word out to perhaps other stakeholders about this profession, I found out about voice writing and about the change in legislation via a newsletter from the Los Angeles Federation of Labor. And I was previously not acquainted with this profession at all before that. And so I would hope that the various federations of labor throughout the state, there are many, especially in the larger counties, might be considered for outreach. I know that not all officials are, represented in their various counties, but I think that those county labor federations, as well as the California Federation of Labor, would perhaps be terrific partners for getting the word out about this just really wonderful profession and, the shortage. I also think that if there's a way to do it, it might be a good idea to poll some of the applicants, perhaps some of the more recent licensees, about how they became familiar with court reporting. It may yield additional information about how people are becoming aware of the profession. So thank you.
All right. This is the moderator, our next individual who has requested public comment. Sarah Wilson, Canada. And Sarah, you'll be given 3 minutes to speak and a 30-second warning. Please click the unmute me button when the prompt appears on your device.
Hi, sorry. My name is Sarah Wilson. I'm a court reporter from Ontario, Canada. I haven't got a question. I just wanted to, first of all, say thank you for having the NAFTA amendment issue on the agenda today. And I just wanted to quickly voice my support of that amendment. I think it could be a real win-win situation for both reporters that are interested in relocating for work and for the areas that have job postings that are going unfilled. And I certainly understand the concern that Mr. Manayan raised with respect to protecting American reporters. I get that. And I think the desire for more data and information is completely reasonable. And I do think that there's a path forward that could benefit everyone, and that the NAFTA amendment is certainly worthy of further investigation and further consideration. That's all. Thanks again.
All right, this is the moderator. Next we have Stephanie Leslie. And Stephanie, you'll be given 3 minutes to speak and a 30-second warning. Please click the unmute me button when the prompt appears on your device.
Hello, thank you for taking my comments again. I am thrilled to have this conversation. We at the DRA have been urging legislators to put in some effort, because I think there's been a lot of grassroots efforts across the country and in California to raise awareness and get people excited about this field that no one's ever heard of. And so I think it's working, and we do have a very high demand and interest in our field. As was stated, there are wait lists at so many programs. I know of at least 2 personally of our 7 or 8 whopping programs across the state. There just are not enough programs to meet the need right now. So I'm excited for you to get data that supports that, because I'm confident that you will. I will tell you, I have been doing this research on the data between the schools and actually trying to shut down some digital programs that are allegedly being offered at our community college. And my tact has been that they are using the term digital reporting, which is no longer allowed via the title protection. So I've been contacting all the community colleges up and down the state. I believe there were 30 something, and I've gotten in some really great conversations with several of them. One of which, or 2 of which, they said, wow, thank you so much for letting us know. We will shut down the program. But by the way, should we put in a real court reporting program? And I said, yes, that would be great. So I have been in contact with them. The problem is, and so I just wanted to bring this to your attention for when you do discuss this offline or start gathering data, the roadblock or wall that we are hitting, there are 2. The first is that the teachers, they need more teachers, the programs that are currently in existence. And some of the positions are simply readers, but because there's a lot of red tape with the state, they're required to have certain degrees, various things. And so if there is any way in your talks with these other governmental agencies to alleviate some of that red tape and allow for teaching positions, I know of several retired court reporters or part-time reporters that would be happy to be readers, would be happy to be teachers.
but the process is just too cumbersome. So that's one of the roadblocks. And the other one is the ambiguity of the duration of school.
30 seconds.
Thank you. So basically, most community college programs have an exact time frame, like 6 months, a year, 2 years, 3 years, but ours is very fluid. So if there's any way to carve out some kind of allowance for some flexibility on the duration, I think it'd be a lot easier to get these programs instituted. So thank you very much. I appreciate all of your assistance, and I'm looking forward to seeing where we go with this. Thank you.
All right, this is the moderator. Our next individual who has requested public comment, Megan Heinlu, Canada. And Megan, you'll be given 3 minutes to speak in a 30-second warning. Please click the unmute me button when the prompt appears on your device.
Me.
We can hear you.
Hi, another Canadian here. My name is Megan Heinlu. I'm a court reporter who lives and works in Edmonton, Alberta. We're currently having our first major snowfall of the season right now. So the idea of California is especially appealing today. And so I just wanted to thank you for your considerations of allowing Canadian reporters to help meet the need for reporters in California, as there's definitely a growing interest among Canadian reporters in working internationally and especially in the United States. Thank you.
All right, it appears there are no further requests for public comment on WebEx.
Thank you, moderator. I saw a hand from Mr. Dodgenham.
Just one observation based on the input and information we've received today. It sounds like we definitely have a shortage of classroom spots or classroom seats for all the reasons that were mentioned. So I just want to caution us or help guide our efforts. It would be a classic kind of business mistake to go out there and drive more demand for this program and then just exacerbate the existing program that there aren't enough seats. So the 3 areas that we talked about, awareness, access, and then supply of seats, we probably need to prioritize that supply piece. And it sounds like that's going to take a little while to do, but I just want to highlight that. I don't want to create a bigger wait list of people that then get frustrated because they can't get into a program.
I would say don't hold back on the awareness piece. Absolutely. I mean, there are sure there probably are international programs. There are national programs. Yeah, schools are done online, so people can go to school anywhere.
Okay.
So please, the awareness.
Got it. So just make that a part of our awareness that
Yes.
these are other sources of classroom learning.
Right.
Thank you, Ms. Unke. Ms. Brewer.
And I just want to tag on to that sometimes the demand for the space comes first.
From the awareness,
for
right.
the schools to respond and see that there's
Great.
a need. We know a lot of schools have closed down their programs, so we need to
Maybe give
them the message that they need this program.
Yes.
I want to comment on, Ms. Leslie had mentioned the programs need teachers, and I'm aware of that situation so the public schools, all their teachers need to be credentialed and hours go into getting that credential to actually be a teacher. So that is a real issue because to be a reader, to be offer dictation, if there's that would be important to find a workaround for that or an exception for that, to not have to have a teaching certification type thing.
Yes, I want to thank Ms. Leslie as well for flagging that. I know, again, my experience is, my professional experience is primarily in the health space, and I know the nursing boards were able to get an exemption for their teachers because they've had such a struggle recruiting, right? Because for similar reasons. And so, there are all these hurdles to get first credential to be a teacher, and so they've been able to kind of recognize that the work experience should count towards your teaching credentials. And so they've run a series of legislation to kind of remove those barriers. So it's definitely possible. I wonder if this is another area we can bring to Assemblymember Colra, Ms. Brewer.
And I would just tag on to that we have a huge cohort of reporters who have just retired or are retiring and would love to have a little something to do. And if there is some way that they could segue into teaching, I think that is a ready market to at least explore.
Other questions or comments from the board? I want to just thank again all of our public comment commenters. As you probably saw, we're all furiously taking down notes because this is all really wonderful information, and you can probably expect us to reach back out for further questions and thoughts, but so appreciate that. Do we comment again because we talked more? Probably.
Mr. Payne, do we need to go back to public comment?
No.
Wonderful. Okay, let's move on to our next agenda item number 11, Best Practice Pointers Task Force. I will turn to Ms. Sunkeys and Ms. Brewer.
The Gabby one just for the zone. Okay, so we've met again. I apologize, I don't have a summary in front of me, but we met again in August and in September, and we made a lot of progress. We finished with we went through all the rest of the current best practices, and it was wonderful working with Ms. Sunkeys. We were co-chairs, and I hope that the people participating felt this way. I felt we worked well together. We had a lot of really great public participation and and staff participation. It was really good. So we came up with these updates that are in finished form. I'm sorry that I did review them all, and I went painstakingly through them all at one point, but I didn't the final version that we just got yesterday, I think. So, and this was a ton of work for the board as well, for the board staff as well. I do have one, I marked this. Just this morning, I was looking at these, and I have one potential change that I would like to suggest. It's just a minor change that's my own little pet peeve on usage, and that is in best practice pointer number 14, the final one that we have here, the last page. We've got this section at the bottom when there is no interpreter, and if you go up to the block of 3 bullet points of that, the first bullet points, the third line, it says it is the onus of the parties. I would prefer to see that language as the onus is on the parties. If we could just make that final change, if people accept that, the onus is on the parties present to provide a Czech interpreter. It's just a usage issue. And otherwise, any questions or comments from anybody else would be welcome. And thank you again to all the people who participated and made this possible.
Mr. Dodgenham.
I know I've said this privately, but I just wanted to say publicly to Board Member Brewer and Board Member Sunkey, to the board staff, and to all of the public that contributed to these. I was completely blown away. This is just amazing work, and really, I think, just so productive and helpful to make this, for all of the consumers of California, to make sure that we're following best practices. So just really, really appreciative of all the fantastic work that everyone did. Thank you.
Ms. Sunkey?
Yeah, and I would be remiss if I didn't call out Ms. Brewer for her attention to detail. We would not be here. We would not have gotten here without that. And thank you very much.
Thank you.
So I'm just along to help in any way I can. But this is the one who really drove the ship. So and also Mary Pierce and Brooke Ryan were the other members of the task force. They were invaluable, absolutely, and we had really good, very helpful input from the public at all our meetings. So I just wanted to mention that.
Ms. Burr?
And I do have one thing to add. Ms. Sunkeys reminded me by mentioning Brooke and Mary, who were fabulous. And that is, we left our last meeting having finished going through all the current pointers, saying, does anybody have anything else, and let us know. And I have had many, many communications from Ms. Ryan with great ideas and suggestions for future pointers, but we would need to meet again to flesh those out.
Wonderful.
I know you've got a list.
I appreciate that that move towards constant improvement. And I want to echo my thanks and appreciation as well towards our esteemed task force chairs. Thank you again for all of that work, all of that coordination, and to our all of the folks who participate in the task force and in the public. So thank you again. With that, do we have a motion?
I don't know if it's appropriate for the co-chair to move it, but I would move I should look at the language. We have staff provide this with us. I move approval as amended of best practice pointers 4, 5, 6, 7, 8, 10, 11, 12, 13, and 14.
Thank you. Do we have a second?
Second.
Ms. Dodgenham. Oh, okay. Okay. Sorry about that, Mr. Menine. You're on a slight delay.
No worries. I'm on delay. So
always a second behind. With that, Ms. Bruning, we will take public comment first. Public comment in the room? Seeing none, public comment on WebEx.
So moderator, we are open for public comment on WebEx. If you would like to make a comment on this item, please click the raise hand icon or use the Q&A feature down at the bottom right-hand corner. If you're an audio-only participant, you can raise your hand by pressing *3 on your device. And it looks like we do have... Oh, I apologize. I had my microphone away from my mouth, and that's why. I'll repeat my instructions again. For members of the public on WebEx, if you would like to make a public comment, you can raise your hand or use the Q&A feature down at the bottom right-hand corner of your WebEx screen. If you are an audio-only participant, you can raise your hand by pressing *3 on your device. And it looks like we do have a request for public comment, Anna Fatima Costa. And Anna, you'll be given 3 minutes to speak with a 30-second warning. Please click the unmute me button when the prompt appears on your device.
Thank you to the task force for your amazing work on this. It was a pleasure and an honor to participate as a public member. I think we did incredible work on this. I mean, you did the work. I made some suggestions. And this is one of the main tools and resources that I discuss with my students at West Valley in my codes and procedures class and in the CSR exam review class, as well as internship. It is one of the top 7 things that they need to study and to know and really understand thoroughly as they prepare to take the California CSR exam and to go out into the field. I was just wondering if you have a timeline on when the revised best practices will be uploaded to the website. And thank you again. It was really a wonderful experience.
Why don't we get everything at the end? Okay. Yeah. Any other public comment?
This is the moderator. Appears there are no further requests for public comment.
Thank you, moderator. Ms. Fenner?
In that case, I'll take Anna's question.
Oh,
Sure. Public comment.
okay, sorry, public comment in the room, thank you.
I'm Michelle Caldwell, CCRA. I just wanted to express our appreciation for being part of that task force. I know Brooke personally called and talked about it often and was appreciative of the work that went into it. And Ms. Brewer, I'm not surprised that she's communicating often about more ideas. So again, just thank you on behalf of CCRA.
Thank you. Okay, just checking one more time. Other public comment in the room? No? Okay, great. Thank you, Ms. Fenner.
I did want to address Anna's question on next steps. So once these are approved by the board, then we send them over to publication and design to make them look pretty, and then we post them on the website. So I can't speak to their workload. I can ask them to give it as much priority as they're able to, and the web team usually can get things up to us within a week.
Great, thank you. Ms. Burr?
I would just like, there's thanks to go all the way around, but I just want to mention that Ms. Costa missed the meeting as a member of the public and had a lot of feedback. And we had other people who attended perhaps every meeting, but multiple meetings. It was a great experience.
Thank you. Thank you again. With that, we'll conclude. Yes. Oh, we need to call the vote. Thank you, Ms. Bruning, again, as always, keeping me on my toes.
Ms. Brewer?
Aye.
Thank you, Mr. Dodgenham.
Aye.
Thank you, Mr. Manayan.
Aye.
Thank you, Ms. Dunkies.
Aye.
Thank you, Ms. Tagare.
Aye.
Thank you, motion carries.
Thank you, Ms. Bruning. With that, we are going to break for lunch. We will return at 1 p.m.
All right, and if I can just get a quick mic check from the room just to confirm that we can hear the audio.
Mic check.
Perfect, thank you. Mhm. All right, this is the moderator. Appears the room cannot hear us on WebEx. One moment while we try to work with these technical difficulties. You.
Laura? Yeah, let's give it another minute.
We just need another moment, please.
Great. We will call this meeting of the Court Reporters Board back to order. Ms. Bruning, would you call the roll once more?
Yes, thank you. Scotty?
Present.
Ms. Bunke?
Present.
Ms. Brewer?
Present.
Mr. Dodge Nam?
Present.
Mr. Manayan?
Present.
Thank you. Quorum reached.
Thank you, Ms. Bruning. We will proceed with agenda item 12, the strategic plan 2024 to 2028. Ms. Fenner, would you update us on the strategic action plan, please?
Sure. So we did reorder as the board requested so that we are in target date order rather than in objective date order. We've added in any information that staff has or we know of with the different task forces. And we're happy to answer any questions.
Any comments or questions from the board? Give everyone a moment. Yes, Ms. Bunke.
I have a couple comments. So we've got to update the board's logo and incorporate voice writing for a more universal, inclusively logo. We've got a target date of June of 2025. I was wondering if we could get started on that. So I think that should be done as soon as possible because it's been a year already that we've been licensing voice writers. And I thought maybe if we get started so we know it'll be done by June. And I'm not sure what's involved, and I know I'm adding to your plate. And but that was one of the things that had crossed my mind.
Okay.
4.1, which that kind of segues nicely into what we discussed today, raise awareness. Well, actually, no, it doesn't. I'm sorry. It is something else. Increase the visibility to promote consumer awareness about the board's role and efforts. I was wanting to know a status of that. If anything's been done in that regard.
No.
Okay. 1.4, research the reinstatement of lapsed licenses and determine if statutory changes are necessary. I wondered if, I hate to bring this up, do we need possibly a committee or task force to look into that?
I think we just need somebody to look into the law and see what the status of the law is, if that's possible, or if we need to change it.
Okay.
I think the way it works is when you lose your license, that number's gone, and you can't just reinstate that license number. You have to retest. There's a process, and I believe it's statutory.
Okay.
So I'd have to look into it.
Okay. And when you say lose your license, like this is not just somebody who would be disciplined, but somebody maybe who moved away or
or retired and said I'm going to use it again, and then here we are 5 years later, and it's like, no, I kind of want to go back to it.
Right.
And you can't just say, no, unless you've kept that in a delinquent status, there's nothing to reinstate. That number is gone forever.
Okay. Okay.
So that's why we have to research the limits of what that says, you know, what the process is for reinstatement.
Okay.
If there is a process for reinstatement on the lapsed license.
Okay. All right. And then 1.6 was through legislation that will require CSRs to complete continuing education. This is so important. I think this would be so helpful to reporters. Definitely, we would have. I think it's important that reporters have continuing education, and I would like to see this legislation pursued at least every sunset review. I mean, if anybody could get that passed, that would be good for the consumers. I think it makes for a better licensee, certainly. And those were my comments. Thank you.
Thank you, Ms. Unkeef. Mr. Dodgenham?
Just three comments really. First, I'm really pleased that we've made some important progress against some of our most important action items with our deadlines. We've accomplished the top three. I think for 1.3, and I don't want to be dismissive of it, so maybe we need a broader discussion, but I think the purpose here was to assess the feasibility of adding on one in-person test annually to improve accessibility and inclusivity. I think we've all seen the budget, and we saw there just doesn't seem to be the money available to do that. Also, I don't think we've seen anything that truly demonstrates in-person testing drives much greater accessibility. So I think maybe we can consider putting that one as complete. We can have a discussion about that. Just want to throw that out there. And then on 4.1, the other one that we kind of targeted for the end of this year, I'm thinking we can talk here about the transcript reimbursement program and about the complaint process, and maybe as part of our efforts of awareness generation that we're going to work with DCA Public Affairs on expanding the training programs. We can also we'll talk to them about leveraging DCA Public Affairs resources to promote those two items on our board, and that would have the impact of helping drive that awareness. Just another proposal thought.
Thank you, Mr. Dodgenham. On those lines, it sounds like 4.7 is also working possibly with DCA Public Affairs. I wonder if it might be possible to kind of bundle those tasks, especially if we're going to be likely creating a lot of new collateral. I'm not sure if, does Public Affairs typically take on the design work, or do they contract that out?
There's a publication and design unit of it. So there's different units within the Office of Public Affairs. So I don't know about bundling, but because there would be different, obviously the people that write the copy would be different than the production and the designers.
Okay. I'll send an email out to just start the ball rolling.
Yeah, just given, I imagine if we're about to create a lot of, like I said, like if we're about to go off and create a lot of collateral, then definitely don't want to have to go back and do it over again, or even if it's having to just go back and recertify it or whatever. If we could just do it in one go, and so maybe that does mean start moving up that 4.7 just to get it out of the way. Mr. Dodgenham?
And forgive me for the question, just sort of understanding a little bit more on how it might work in the state government sector. Are there very strict rules that logos have to be done through the State Department, through Public Affairs Department? I'm thinking versus opening it up to our members to develop logos and promote, to submit them for a prize or something like that. Is that like something you can't really do in this kind of government work, or are those things possible?
No, I do think there's a process for it. I'm aware of it was a bureau, so the bureau process might be different than a board, but there was a process that the Bureau had to go through to change its logo.
Okay.
Likewise, Department of Consumer Affairs changed its logo, and again, that had a process to it as well. So I think we might need to touch base with boards and Bureau and exec on how, if that were something that the board wanted. Yeah.
And just as a caveat, when we use services through publication design and editing, that's part of our pro rata.
Okay.
So there's no extra cost to the board.
Oh, got it. Okay. Just wait. Good to know. Yeah, sooner rather than later.
Ms. Burr?
I was just going to reiterate what Board Member Dodgenam said, is that 1.3, I was wondering if we needed to mark it as completed or change it, because I don't see us doing this.
I agree with that assessment, Ms. Brewer. Other comments or questions on that from the board?
Which number was that?
1.3.
I agree.
Thank you, Ms. Sunkeys. Ms. Brewer? Okay. Thank you. Any other questions or comments from the board or discussion on the strategic action plan? Okay. Seeing none, we'll go to public comment. Any public comment on agenda item 12? Seeing none in the room, moderator?
All right, this is the moderator. We are open for public comment on WebEx. If you would like to make a comment on this item, please click the raise hand icon or the Q&A icon down at the bottom right-hand corner of your WebEx screen. You may also, if you're an audio-only participant, raise your hand by pressing *3 on your device. And it looks like we do have a request from Stephanie Leslie. Stephanie, you'll be given 3 minutes to speak and a 30-second warning. Please click the unmute me button when the prompt appears on your device. All right, Stephanie, and you are unmuted. Stephanie, if you're currently speaking, we cannot hear you. I'm not sure if you need to get closer to your microphone or perhaps do a different audio connection.
Moderator, do we have any other public comment?
This is the moderator. At this time, we have no other requests for public comment.
Okay. Happy to return to Ms. Leslie if she's able to get back on. But for now, then I think we will close public comment.
Okay.
Thank you. Do we need to vote on the strategic?
No, these are just instructions to staff.
Okay, great. So with that, we will move to agenda item 13. Ms. Fenner, would you give us an update on the expedited fees for deposition?
Yes, so last fall the board instructed staff to locate an author to change the necessary laws to allow court reporters to charge all sides ordering transcript expedite fees. All sides that ordered the expedite fee. That wasn't phrased very well. Laura could have jumped on that one. Staff has been unable to secure an author. In discussions regarding a bill to clarify what a court reporter may charge to the public, staff discovered that such a change in statute would be better served coming from one or more of the trade associations. As a consumer protection agency, the legislature tasked the board to put forth legislation that benefits the public, even if it's contrary to the interests of the licensees. And I'm happy to answer any questions.
Ms. Burr?
I don't have a question, but I have comments.
Thank you.
We obviously discussed this and gave this a lot of thought and covered it thoroughly over 2 meetings. And my view hasn't changed, so I think you all know how I feel about it. Reporters have to provide services equally to all parties. And reporters have a duty to treat parties equally. And I believe it's inherently unfair to provide something free to one party while charging another party. I think it's unfair to the point of subsidizing one side's litigation. And so that has always been my view on this issue, and it's my view unchanged now. I would also add that I commend our board staff. They're fabulous. But I was dismayed to only hear about this, about our decision not being upheld just before this meeting. And perhaps my recollection of what we were told and what transpired is incomplete or inaccurate. But I thought I even asked if reporters would be disciplined or not disciplined on this matter going forward. And my understanding now is that they have been, and it's been treated as it was before our decision. So I'm disappointed about that. And those are some of my comments. Oh, and I would have one other comment, and that is that only fees for officials are covered in statute. No fees for freelance reporters and depositions are covered in statute. And so my position on this would be that we don't need statute authority. So my position would be, fine, we can't get an author, we drop it. But not that we drop our change in policy for how it's handled, but we drop any effort to secure an author for legislation. I don't think we need legislation. I think it's covered.
Thank you, Ms. Burr. Ms. Unkes?
As we discussed extensively at our September 1st and December 13, 2023 meetings, consumers of court reporting services must be treated fairly and equally. To ensure that occurs, they hire licensed court reporters who act as neutral third parties. Consumers hire court reporters to record legal proceedings via machine or voice and produce transcripts of those proceedings, for which they are charged a fee. Often consumers request value-added services for which they are charged additional fees, for example, real-time hookups, rough drafts, expedites, etc. And looking at Agenda Item 9 from the December 13, 2023 meeting, we as a board were presented with 2 options. 1, maintain the position taken by the Court Reporters Board previously and clarify that position in regulation or legislation. Or 2, and this is a quote from the board book from December 13, quote, in the alternative, the board may take the position that any party wanting the transcript on an expedited basis must each pay a fee, in which case the board will update its website with the revised position, close quote. I moved the motion at the December meeting, quote, that expedite fees can be charged to all parties, close quote. The motion was seconded, and after further comments by the public and board, the motion passed. Perhaps the motion was not succinct enough. Perhaps I should have worded it differently. I moved the board take the position that all parties ordering an expedited delivery of their transcript may be charged an expedited fee and direct board staff to update its website with the revised position. I apologize and take full responsibility for the motion, the way it was worded. If that is what is necessary to carry out the vote and position of the board, I would request a meeting as soon as possible with this agenda item. However, I will note that in reviewing the minutes of the December meeting, on page 17, it was stated, quote, if the board finds that a court reporter may charge a copy party expedited fees, then the board must a legislative change to alter the statute. Quote, that was a close quote. Code of Civil Procedure 2025.510 was cited extensively as it applies to transcript costs. The relevant portions of 2025.510 are as follows. B, the noticing party shall bear the cost of transcription unless a court orders otherwise. C, any other party or deponent at the expense of that party or deponent may obtain a copy of the transcript. And D, the transcripts shall be made available to all parties at the same time. During our discussion in December, why we would have to or want to pursue a legislative change. Again, I apologize for not questioning this at the time. The mission of this board is to protect consumers of court reporting services by taking the position that all parties ordering an expedited delivery of their transcript may be charged for that value-added service ensures they are being treated fairly and equally. This position does not run afoul of the applicable statute, CCP 2025.510. Therefore, I question why it would require a legislative change. And I did some research on the code section, the applicable law, the 2025.510, Code of Civil Procedure 2025.510. It was introduced in 86, 87 by CCRA. At the time, Diane Sonner was president. That was her first term. She was also president in the 90s. Diane was a freelance firm owner. She and Gary Kramer wrote this legislation and introduced it. Diane said the code section was never intended that only one side pays an expedite fee. Her practice was, she told me her practice was to charge an expedite fee to whomever ordered an expedite, received an expedite. I'm sorry, let me clarify that because that was saying two different things. Her practice was to charge an expedite fee to whoever received an expedite transcript. She said, when I spoke to her, she said, you know, let me go back and review the code section. And she called me and she said, I'm confused. And she said, where does it say only one expedite fee can be charged? I don't see it. And I pointed out the made available at the same time language in the statute. That seems to be, I guess, where the interpretation was made. Diane had said, you know, all services are made available at the same time. That's for fairness and transparency. Again, her practice was to charge the expedite fee to each party receiving the expedite. And that's from the person who wrote the language and introduced it. So again, I don't understand why we would need any legislation, a legislative change, and because this position does not run afoul of that. And I think that, well, I've stated my position.
Thank you, Ms. Unkees. Ms. Brewer?
I just want to follow up with one thing, that made available at the same time or made available. Same thing with regular copies of transcript on a normal delivery schedule. They're made available for a cost to the opposing party. Just because they're entitled to it doesn't mean they're entitled to it with no charge. And it is charged.
Thank you, Ms. Brewer. Other comments or board discussion?
Okay.
I think, I don't have prepared remarks, but I'll just have to go off recollection from the meetings. As you know, I was the dissenting vote in that motion. First, I think, as I recall, it was our legal counsel gave us the interpretation of the law, and that we had to follow, that we followed as the board. I'm not an attorney, and so we rely on that interpretation that they provided, and I think we worked within the constraints of that. The comments that were made are compelling and great research on talking to the authors, but I think that is still a legal issue for the DCA legal team that we work with. You know, and we as a board, based on that interpretation, I don't think can make the changes that you're requesting without that, go ahead from legal. And then secondarily, even, hearing this, I still have concerns about the consumer, about one side being able to pay to expedite and get sooner, and the other side having to pay if they want to keep up with that side. So I saw it, or you see it as being equal one way, I see it as potentially harmful to a consumer that would have to pay more to keep up with the side that has deeper pockets and can pay more. So then I think the other arguments were not enough to convince me otherwise that it's more beneficial to the consumer the other way. I just can't see that. So again, our motion passed before. We've seen the response from the legislature. They thought we got it wrong based on this, but my perspective hasn't changed on that either. Respectfully.
Thank you, Mr. Dodgenham. Just for clarification, Ms. Fenner, that information is not coming from the legislature, it's coming from Board and Bureau Relations, is that correct? It's come from multiple sources within the Department of Consumer Affairs. Okay, thank you.
Okay, sorry.
Thank you.
I thought it was a legislative author, but it's a Board and Bureau.
Thank you. With that, other discussion from the board? Okay. Yes, Ms. Brewer.
At the risk of repeating myself, I will just say that these arguments are the same arguments that could be made to say that court reporters can't charge for real time because it's being provided to the other side, and if somebody wants to keep up, they're forced. If they want to buy a copy, if they want to have a copy, they're forced to pay to keep up. If they want to have a real time, a rough draft transcript, they're forced to pay to keep up. I mean, that's the nature of the beast, is services cost money. So I really will stop at that.
Thank you, Ms. Burr. And Ms. Sunkees, just so that I have it noted, was that a formal request to add this item to a future agenda?
I think we should talk about that offline.
Well, okay. If that's what it's going to take to have the CRB to change its website, that it's what was it? The board will update its website with the revised position. Then that's what I would request. But I never requested legislation. Somebody pursue legislation, and we were not told that this vote would mean that we were required to change legislation. It doesn't make any sense for us to go in and request legislation to say to regulate, to set fees. The legislature has made it clear in the freelance arena, they're not regulating the fees. It's a free market, is my understanding. So I know I'm giving you more information, answering with more. But if that's what it would take to get to make the motion, to expound on the motion that the board change the website to this new position, then yes. But again, I never, in the motion, we didn't vote to pursue legislation. That was the position that board council, that was in the board council's comments as a result of the motion, of the vote. So that's what I call that into question. But I'll just leave it at.
Thank you, Ms. Menkes. Well, I know we have an agenda item later for future agenda items, but maybe we can return to that then. Okay. With that, we seeing no further board discussion, I'll just making sure Mr. Manayan. No? Okay. Then we will go to public comment in the room. New public comment. On WebEx, please.
All right, this is the moderator, and I've opened up a public comment on WebEx. If you'd like to make a public comment on this item, please click the raise hand icon or the Q&A icon down at the bottom left-hand corner. If you're an audio-only participant, you can raise your hand by pressing *3 on your device. And we do have a couple of requests. First, I have Carly Savar. And Carly, you'll be given 3 minutes to speak and a 30-second warning. Please click the unmute me button when the prompt appears on your device.
For what it's worth, I agree. I think for fairness purposes, court reporters should be able to charge an expedited fee to both sides. But if the board does decide that you have the authority to post revised guidance on your website, I'm just curious how you would deal with the Serrano case. And I apologize, I wasn't at earlier board meeting, so you may have discussed this. But I know the court felt that court reporters,
I'm sorry, please refrain from referring to ongoing cases. It's litigation. Oh, sorry. Thank you.
It's not, yeah, that isn't litigation. It's an older case from 2008 that interpreted the CCP 2025.510, which said the cost of transcription must be borne by the party noticing the deposition. So it found that charging an expedited fee was double dipping. And I think that was on the Court Reporting Board's website earlier. So I'm just curious how you would handle, if there would be a conflict between your guidance and, this court guidance. And so I don't know if you guys have thought about that.
Thank you. We'll address all questions at the end, but yeah, my apologies. That was in order. Moderator, are there other comments?
Yes, this is the moderator. Next, I have Mary Pierce. And Mary, you'll be given 3 minutes to speak and a 30-second warning. Please click the unmute me button when the prompt appears on your device.
Good afternoon. You can hear me?
Yes.
Okay. I'm going to apologize in advance for being scattered. I was not prepared to speak to this, but I do have some opinions. First, I want to thank Laura Brewer and Robin Sunkes for their eloquent comments both today and previously. Laura's original comments months ago were all encompassing, very thorough, and I thank her for those. I hope you all recall everything she said back then. And Robin's comments today were right on point and, again, very thorough. I will go to the language of the CCP says that we shall make available. And like was pointed out today, just because one attorney in the deposition or courtroom gets real time doesn't mean everybody else after them gets it for free. That is unfair to whoever raises their hand first, which is an unfair penalty. And this, the issue of charging expedite at all is not addressed in the CCP. So I think this is an artificial interpretation and an artificial limitation to say that we cannot apply equal charges to other people who choose to get a value-added service. So I think that with there being nothing in the CCP addressing this, placing an artificial and illegal, in my opinion, limitation on free market trade is not substantiated by the current language of the law. And I think that this was fully addressed and voted on, and I just don't understand what's going on today to reverse what happened in 2023 and the past motion. And I think that legal counsel's opinion from the DCA is, personally, I don't think it's well-grounded. I don't know if this is someone who has practiced litigation, certainly civil litigation. And I think that it's not a binding precedent of any sort, and I would object to any litigation. And I would encourage the board to act very swiftly on this. This has drug out too long already, was already resolved as far as I understood, and I just don't want to see this go backwards. Please go back to your prior decision, make any adjustments you need to make, but please, let's not try to pursue legislation when nothing else is legislated except for equal charges to all on rough
30
copies
seconds.
and real time. Other than that, like, we all know how slow the legislative wheels turn. It's not required nor fair to make the legislation be the final arbiter of this discussion. Thank you very much.
All right, this is the moderator. I have Stephanie Leslie next. And Stephanie, you'll be given 3 minutes to speak and a 30-second warning. Please click the unmute me button when the prompt appears on your device. All right, Stephanie, you are unmuted. Stephanie, fortunately, it appears we cannot hear you if you are speaking. Stephanie, what you might want to do is you can either type your comment in the question and answer option down at the bottom right-hand corner of your WebEx screen, and I can read your comment aloud. Alternatively, what you can do is you can go up to audio and video, click switch audio, and then follow the prompt to call in on your cellular device. Sometimes the connection is a little bit more stable over the cell phone rather than your Wi-Fi on your computer. I'll keep your hand raised in the meantime. We'll go to our next person requesting public comment. Anna Fatima Costa. And Anna, you'll be given 3 minutes to speak and a 30-second warning. Please click the unmute me button when the prompt appears on your device.
I want to support Mary Pierce's comments. She was very thorough, and also appreciate our licensee board members, Robin Sunkeys and Laura Brewer. You thoroughly covered this topic, as Mary said before, and your thoughtful, detailed examination of legislation and what is happening out in the field, I wholeheartedly support. Thank you. And to Laura's point and Mary's as well, we shall make available all services and products at the same time to all parties. As a former manager of an agency in San Francisco for 5.5 years with global reach, I knew this very, very well. And there are attorneys who do not pay for services, therefore asking for payment in advance is appropriate and proper. We, as independent contractors and business people, because whether reporters are officials in various courts in the 58 counties in California, they are both employees and independent contractors when they are asked by attorneys for products such as transcripts, real-time, rough drafts, expedites. They are independent contractors as well, 1099s. Therefore, in my classes, I talk to my students about this. Yes, you must offer services and products at the same time to all parties. But as business people who are also charged with the duty of protecting the record, do they not deserve or need to be paid for their hard work providing those services to all parties who request them, and to get paid to do so?
30 seconds.
Impartially offering and providing these services to all parties. And thank you very much. I agree with Mary. Let's put this to bed, shall we?
All right. This is the moderator. We're gonna try. It looks like Stephanie connected her audio to her phone, so I'll try unmuting you again, Stephanie, and you'll be given 3 minutes to speak and a 30-second warning. Please click the unmute me button when the prompt appears on your device.
Okay, did that work?
Yes, we can hear you now.
Oh, good. I thought I troubleshot it, but apparently not. Thank you for your patience. Okay, so as an agency owner, as well as president of DRA, I have been operating my agency since December based on the information I was given at the last vote. And I'm often consulted from colleagues and from our membership asking what happened, what's the latest, and I was proud to be able to tell them that there was a vote taken and that we were able to charge for expedite. So to hear that there have possibly been disciplinary actions taken against my colleagues since then is quite disheartening. I thought that's what you said. And if that's the case, I would very strongly request that those be rescinded retroactively, because that doesn't seem fair to me. So whether or not legal has recommended to the board to go a certain direction or not, there was a vote taken. So, you know, according to all the rules I know, Robert's rules and otherwise, it seems like that should be the decision of the board until otherwise voted upon. And I really thank you so much to Robin and to Laura for your thoughts. They're very well articulated and well thought out. And I love the fact that you went back and got the history from the person who wrote the legislation. That says everything. So I hope that the board will reconsider, and I look forward to hearing your decision. Thank you.
All right, this is the moderator. Appears there are no further requests for public comment on WebEx.
Thank you, moderator. Was there further board discussion? Okay.
Random
Mr.
point,
Dodgson.
random point. I know Ms. Leslie had tried to have comment about the strategic plan earlier and wasn't able to connect. Now that she's able to connect, I wanted to just give her an opportunity if she still had comments.
Oh, yes.
On the previous.
Yes, happy to. Ms. Leslie and moderator, if Ms. Leslie still has public comment in regards to agenda item, I believe that's 12, happy to return to Ms. Leslie.
Sure. Stephanie, if you wanted to make comment on agenda item 12 again, please go ahead and raise your hand and I can unmute your microphone. All right. And then you'll be given, once again, 3 minutes to speak with a 30-second warning.
Well, that was very kind of you. Thank you for circling back and getting us off track a bit. But I did just want to, I wasn't sure of the procedure with regard to the strategic plan, and if the only updates being made to it were in that last column about the dates that things are happening, or if changes are still able to be done to the strategic plan, because I still have great concern over 2.2, the December 2028 target to potentially license digitals. I've been told by CRB board members that that is not in the plans, but it's still on the strategic plan. So it does greatly concern me. So I just thought I would put that out there, that we are still in great disagreement about that potential for the future. Thank you.
Thank you. Okay. With that, do we have any comments for us Okay. With that, this was an informational item. Moving back to agenda item 13. And so we will move forward. On agenda item 13? Sure. Welcome to.
I didn't originally make a comment because I was a little bit confused also why this was put back on the agenda. And when Ms. Sunkeith started talking, it did sound like somebody was disciplined. And I wasn't quite sure reading between the lines, but if that's the case, I just wanted to reiterate, and I echo Ms. Leslie's comments that if somebody was disciplined, that I would strongly consider that you rescind that. Thank you.
Ms. Gaskell. For clarification from board staff, is it appropriate to share if there have been any disciplinary actions related to this issue?
There is not in the time frame that they're talking about.
Thank you. With that, Mr. Payne, do we need to take public comment once more?
No.
Good.
No,
Okay.
we take public comment for each agenda item, and we've done that.
With that, we will move to a 15-minute break. So we'll come back at 2:15. We were going to call, thank you, moderator. We are going to call this meeting of the Court Reporters Board back into session. Ms. Bruning, would you call the roll again?
Yes, thank you, Mr. Kade.
Present.
Ms. Sunkeith.
Present.
Ms. Brewer. Present. Mr. Dodgenham.
Present.
Mr. Manayan.
Present.
Thank you, quorum reached.
Thank you, Ms. Bruning. Let's move to agenda item 14, AI-generated deposition summaries. Ms. Fenner, would you introduce this agenda item for us?
Thank you, Chair Tugade. Some court reporting firms have begun offering deposition summaries, which have been generated with artificial intelligence, or AI. Board staff has received questions on California Code of Regulation, Title 16, Divisions 24, Article 8, Section 2474, which prohibits a licensee from producing or assisting in the production of a deposition summary. Since Part A of that regulation defines a deposition summary as information dictated by an attorney and reported or transcribed by the court reporter at the conclusion of the deposition, staff does not consider the AI-generated depo summaries to be a violation of the statute. If the board finds it unclear, they may want to clarify it by updating the regulations. And the actual language of the regulation is on page 97 in your meeting materials. And I'm happy to answer any questions.
Thank you, Ms. Fenner. Board discussion. Ms. Brewer.
So I suspect I'm going to be the outlier here, but I see this as a problem. So first off, I understand that this is the code section that this falls under, and I think that that code section is, it doesn't address this. This is new. This is new, so it's not addressed in our regulations. And I looked on NCRA's site because they have COPE opinions, I forget, Committee on Professional Ethics, COPE opinions. And so members can ask them questions and they have a committee and they will give an advisory opinion. So I went and looked, they don't have anything on this either. They have the exact same stuff that's on the depo summaries that are dictated by lawyers. And so I did ask them for an opinion, but I only did that yesterday or the day before. So it'll take a while for that to be generated. But so that's the first point to me, is that our current statutes aren't on point because this is a new thing. And to me, we don't have enough information to make a decision. So my questions and the information that I need to be comfortable with this is, are these things fungible, you know? If one party, if defendant A asks for a depot summary, is it the exact same input and depot summary that defendant B would get if defendant B asked for it? Or plaintiff A, if plaintiff A asked for it. So in other words, is it customized at all depending on the party? So that's number one. And then number two, are the opposing parties given notice of the request or the order? Because as court reporters, we are bound to make all services available to all parties. So if defense attorney A asks for a deposition summary, I think at the very least, we need to have regulations that require that the notice of that request and order be given to all other parties and that they have the right to purchase the same thing. So that's number two. And then number three, to me, okay, so the request, are they able to purchase it? Is it the same? And then to me, just the act of summarizing means that you are trying to draw the salient points out of a deposition. And that, what is a salient point is an opinion. I don't care if it's the person's age or their educational background or, you know, who their employer was, whatever, just the act of what you decide to put in that summary, AI generated or human generated, it's putting your finger on the scale of what you think is important. And I think it's completely inappropriate, my opinion, I think it's completely inappropriate for reporters to do this. And if this is a product that's customized to each client request, then I think it's inappropriate because that's not our job. You know, our job is to be impartial and to provide impartial products that a court reporter produces. And number two, if it is fungible, the attorneys can do it. They can buy software and do it. So why is the court reporter providing it? I don't see a compelling reason for the court reporter to provide it. And I don't see that outweighing just to me, the appearance of impropriety. So those are my opinions, and I would request, so my point is that I think we need more information before we decide anything. But as of now, with the information I have, it smells to me. I don't like it. And I might be the only person who was struck this way. I had this discussion with my husband, who's an attorney, and he said, what's wrong with it? It's AI generated. They're not, the court reporter isn't deciding. And so I went through these arguments, and he said, yeah, I see you have a point. So those are my thoughts.
Thank you, Ms. Brewer. Other board discussion? Mr. Dodgenham?
I really was compelled by what Member Brewer said, that two things. One is AI still has input. It's not an objective thing. It's based on the inputs that are put into it. It's how it's programmed. It can come out, and by definition, a summary can be, you know, tipping the scale. So I think that's a compelling thing to think about. I had two questions, just as I'm trying to understand. Maybe you guys that are court reporter members can enlighten. Do court reporters do any kind of summaries today, and how are those used in any way? Is that anything that's used? And I'm seeing the shake of heads no that we don't. So I also compelled by what Member Brewer said about this belongs in the world of the attorney, not in the world of the court reporter. So
yes, Ms. Brewer.
Follow up with one thing to Member Dodgenham's question. So what products that reporters routinely provide now, or I'm old, so maybe nobody even does this anymore, but we would provide word indexes, like a concordance, and a mini transcript. So, but that's inherently objective.
Mini transcript?
Mini transcript is just a transcript, but it's like 4 to a page.
Oh, all on one page. It's a whole
one page. That's like if you have a PowerPoint that has 4
but it's
slides.
a complete transcript.
Complete. There's no
summary.
Selection, no summary, no work product that goes into that, other than producing the transcript.
Yes, Ms. Sunkees.
Yes, I would. I actually ditto Ms. Brewer's husband's comments because initially, when I read this, I was thinking it wasn't an issue, but I am too compelled by your comments and think that we need to get more information because, well, AI is new, right? It's coming on, it's not that new, but it's new to us in our field and how it's being used. And so we need to, if this is not something that's, if this is customized in any way, not applicable to all parties, then we need to look at, possibly look at a new regulation prohibiting its use.
Thank you, Ms. Sunkeys. I share all of your concerns that have been raised. Mr. Dodgenham, I think, brought up a great point about, AI does not exist in a vacuum. It's fed information. It's not creating information. It's generative, so it's just copying information. And so there's an algorithm making decisions, and what you feed it is what is eventually teaching it to make decisions. And then a human still does need to make a decision at the end of that. And so I am struggling with that, with especially given that court reporters don't currently provide this service. I know that the legislature and DCA in general has been moving towards, and this board has moved towards technology neutral language in general. And so, given that court reporters don't provide this service now, I don't know that it makes sense to create a way for court reporters to provide that service in a different way, given technology neutral, regardless of the way in which that is provided.
And I will just point out, it shall be considered B on code of regulation. I'm sorry. The last paragraph on this page, it says it shall be considered unprofessional conduct to provide these things. So not only are they not doing it, but it's considered unprofessional conduct. So.
Thank you.
But if you go back to A, which is the definition.
Right.
If I could provide my 2 cents.
Oh, thank you, Mr. Manayan.
Just as an attorney, and I've used AI programs just to summarize, just giving you my anecdotal experience. Using AI to summarize documents or whatever it is. It can be a simple short document or a complex document. The information and summary that it puts out, you have to take it with a grain of salt because it's not always accurate. It's not always consistent. So and just agreeing with some of the board members, what they mentioned, right? It's not perfect, and it's what you provided and what you feed into it is what you get out of the AI program. So I'm a little hesitant in that. And just by the definition, it says deposition summary. It's some means information dictated by an attorney and reported in their transcript. So I think in line with what's just the plain reading of the regulation, I'm not sure that a AI generator can be considered an attorney. Cannot. So I'm just hesitant. We have to be very careful with what we decide here and how we move forward.
Thank you, Mr. Manayan. I think we had Mr. Dodgenham and then Ms. Sunkeys on the docket.
And I think I'm agreeing with Member Manayan on the point that I have some hesitancy that this statute or this regulation here dictates this artificial, that we can use this to regulate. And I agree that this may not be the right regulation to it. It doesn't change my concern about these AI summaries, and so that might be a separate issue from whether we use this. I'm not saying we use this to prohibit it, but I think we need to think very seriously to have an opinion and explore these AI summaries in general as part of our purview.
And that's exactly what I was going to point out. I know that this is not applicable. Mm-hmm. This is not saying talking about the AI generated summaries. it would be, do we need another regulation that specifically prohibits it? Is that so?
Or do you include it in here as an additional definition?
Right.
And I would say again, you know, in line with staying technology neutral, do we just clarify in the existing regulation that AI is included in
the definition
of
deposition
summary?
Chair, if I could just point something out, this is policy discussion is absolutely for the board, but what I would say in regards to this regulation, under this regulation, the way it reads, attorneys can have their hands in a deposition summary in some way. But court reporters, shorthand court reporters cannot. It says even assist. How might they assist? Maybe they push a button to let an AI do a summary. I think more specificity is always a good thing. That's a great idea to maybe further clarify this regulation to say that it includes AI. Factually, assist could occur in many different permutations, how a shorthand court reporter might assist in a summary. None of the attorney ones seem passive, but in subdivision B, the court reporter reference is read broader than that. And so I think it's definitely something for this board to consider when we're thinking of the full scope of which actor and what are they doing in regards to this regulation. This regulation talks about attorneys, different ways attorneys can provide deposition summaries, and then, so that's an affirmative action that a party or an attorney can do. But then it goes on to say what court reporters cannot do and tries to be broader about what they cannot do. Doesn't say what they can do, it says what they cannot do. So for this board, you may want to consider what does that prohibition encompass? Because you're not worried about what the attorneys can do. You're worried about what the court reporters cannot do. It's a little trickier because this regulation is defined in the negative as opposed to the positive. But given that, you may want to flesh out a little bit more what that means. That helps.
Ms. Brewer and then Mr. Dodger, do you have a comment? Okay.
Is it appropriate for us to ask your opinion or recommendation as to whether we flesh this out if we come to a policy decision that we do not want to allow the AI?
It's not appropriate for me to opine on a policy matter for the board, so it would depend what you all decide. Right. I think if you all decide, for example, to further clarify this regulation, I think legal would work with board staff in accordance with the board's recommendation to clarify it as the board wished. Yeah.
Mr. Dodger.
I think, maybe tell me what I understood Member Brewer to be asking, and tell me if I'm right, this is what I'm asking, is if we as a board come up with a policy that we think artificial intelligence needs to not play a hand in any kind of summary of transcripts, that's our policy. Can we then ask legal to help us figure out, is this statute the right way to enforce that policy, or do we need to do something, or how do we enforce the policy that we...
What I would say is I think legal would work with staff to come up with options for how to effectuate that direction. What I would guard against is the board coming up with a policy and have it be an underground regulation. And nobody's suggesting that here. I just want to guard against that if the board does come forward with a policy, that they effectuate that policy in some way, either through clarifying an existing regulation, creating an AI regulation, some way we can point to say that regulation, that statute is what we're enforcing.
Thank you, that's appreciated.
I've got a question. How do we find, or is it my turn?
No, please.
Okay. How do we find out about these AI-generated summaries to answer the questions that were well raised by Ms. Brewer about, is it a customized summary? Is it Is it a summary, the same summary, a summary, period?
If I had staff, I would task them with it.
Right.
I think it's essential to the decisions that you guys want to make. I agree with Member Brewer that without those questions being answered, it's difficult to know really how far you want to go with that regulation, whether it's innocuous or whether it is crossing the lines of bias that have been pointed out. So I would be happy to look into that for the next meeting so that you have the information that you need.
Wonderful. Thank you, Ms. Venner. And, you know, I would add, I think that a roadblock we may come to in this research process is that generally many of the AI companies have been very, yes, opaque, let's say, thank you, Mr. Dodgenham, with their algorithms. And so we may find that it will be challenging to get more information on that because it's in some ways proprietary, but in some ways also that is key to our decision making, right? About how is this
What
are
the parameters?
Yeah, what are the parameters of this tool?
Right. Is this some program that anybody can purchase? Yeah, that would be something
Yeah, and
the key
I
is
just want,
what you pointed out. Is it the same for everyone?
Yes, Mr. Manayan?
yeah, I think to that point is I'd like to know what programs they're using. Is there a specific program? I know there's law firms, for example, have adopted certain there are AI programs specific for law firms in the legal space. So I'd like to know what they're using, what the inputs are, and kind of the parameters around that.
Exactly. What are the inputs?
Ms. Burr?
What are the inputs, and more specifically, when the depot agency is providing this, do they add any input to it? And if they were, as Ms. Fenner reiterated, is it the same? And if they regenerated it another time, is it going to be the same, or is it going to be different? Boy, I'm very skeptical that it can meet the smell test.
Thank you, Ms. Burr. And actually, I think I'll reiterate a question that I think I had asked Ms. Fenner privately, but we'll put out here is something that I know I'm concerned about is whether the consumer is aware that they're receiving an AI-generated product versus not. And so ensuring that that's labeled and whether, to your point, has it been altered since being generated? You know, that's all key consumer protection information. Other board discussion? Okay, Ms. Fenner, do you think you need to?
I do.
Okay, apologies for giving you all more on your plate. With that, let's move to public comment. Any public comment in the room? Thank you.
Expanding on the concept of the generative AI, one of the things to be aware of is that generative AI takes everything that it had learned before. So every other deposition that's been put in is helping it decide what to choose from that deposition. In the case of a law firm or something like that, they're only dealing with their cases or publicly available depositions. In the situation with an agency, they're dealing with every single person's deposition, which is not public. And consequently, we are commanded to keep it confidential. And to put it into generative AI means that AI is going to use that information to make decisions about how it summarizes each new deposition that it gets. And that's something that could be in direct conflict with what we are required to do with each individual deposition.
Thank you. Any other public comment in the room? Seeing none, thank you. We'll move to WebEx, please.
All right, This is the moderator, and we have opened up public comment for people on WebEx. If you would like to make a comment, you can raise your hand or click the Q&A icon down at the bottom right-hand corner of your WebEx screen. If you're an audio-only participant, you can raise your hand by pressing *3 on your device. All right, and we do have several people who would like to make comment, so we'll go in order received. First, I have Mary Pierce. And Mary, you will be given 3 minutes to speak and a 30-second warning. Please click the unmute me button when the prompt appears on your device.
Hello again. And I want to apologize. I don't know who is seated immediately to Yvonne Fenner's right, but I would like to correct some disabuse you of your position that these are not currently being provided. I can guarantee you and assure you that they are. And that is why I asked this to be put on the agenda, because I am I'm being asked for them, and I may be losing clients or potential clients because I've so far taken the position that I'm barred from providing them. This is an unequal playing field. I'm being hamstringed from competing against firms that have way more deep pockets to pay for lawyers than I have. I would like to address a couple things about, and I do have some knowledge about how these are being produced. You can, there are multiple platforms from ChatGPT to Smart Depot to Claude, which is part of the Anthropic, I believe, website, highly respected. And then there, you know, some of the big boxes have their own proprietary software that create these. You can get a generic summary, or you can customize it by saying, please address these questions. So there are different formats that can be got. I just think that there needs to be an immediate ruling about whether these can or cannot. And if you decide that they cannot, you need to put handcuffs on the big boxes so that they cannot drive me out of business. I'm a small agency, and I believe in following the rules and the laws. And I've had 2 requests in the last 3 weeks. Can I please start providing these? And I said, it's going to be addressed at this meeting today. Let me get back to you. I think that because I was looking at this language and I thought, based on the strict language of an attorney dictating and a court reporter writing that, okay, well, that's not what I'm doing. I have a small enough agency, I take half the depositions. So if, as the reporter of record for that proceeding, I'm barred from creating an AI generated summary, again, you're going to drive the mom and pop shops out of business, the individual reporter. And I am very good at my job. My clients love me. I am not going above board. I'm not going out of line saying that.
30 seconds.
They tell me so. So please keep in mind that it's got to be equal access for all of us on both sides of the board. These are being provided. We need instant judgment about what is provided and what is not, what is legal and what is not. Thank you very much.
Thank you, Ms. Pierce. And just for clarification, I think we were referring to whether deposition summaries are currently being
the traditional way that it's defined under the code where the attorney dictates those. Correct. Those are not being done. The AI generated ones are being done.
Yes, I think that's what we were referring to. Okay.
I think that's where the confusion.
Thank you. Thank you for that clarification, Ms. Fenner. Moderator, do we have any other public comment on WebEx?
Yes, we have a couple more. Next, I have Anna Fatima Costa, and Anna, you'll be given 3 minutes to speak and a 30-second warning. Please click the unmute me button when the prompt appears on your device.
Are you able to hear me?
Yes, we can hear you.
Okay, thank you. I want to also agree with Mary Pierce, and she is a firm owner, so she has a great deal of experience besides her long tenure in our noble profession. This month marks my 45th year in the field of court reporting, having had many roles, including sales of court reporting services and products. Since 1979, I have worked with hundreds of lawyers, paralegals, and legal secretaries, and several of them I still call my friends. And as a former litigation secretary supporting a partner at a small law firm in Marin County, I have in-depth knowledge of what's going on in law firms. It's my understanding from my colleagues, core reporters, and other people who work in the field, that some core reporting agencies, and I think the language that is in that item number, some core reporting firms are offering deposition summaries that are created using AI, and they are not aware of it going into it. Or some of these agencies, the big box agencies, are requiring court reporters to accept a job, which includes this as a possibility that there will be AI generated deposition summaries, or they don't get the job. I think this is coercive, and maybe, I don't know, that doesn't seem legal to me. So these agencies are utilizing Zoom's Fathom AI feature to create spontaneous notes. In fact, you can see a video box on Zoom with note-taking or note-taker as the name of the participant during a remote deposition. And some attorneys enable this feature before or during a deposition and then offer these quote-unquote notes to opposing counsel, thereby bypassing the core reporter, potentially being paid for rough drafts. In essence, they're getting an AI-generated so-called real-time rough draft. I think a modification of CCR 2474 needs to include language that clearly states, as a reminder to attorneys and the public, and include references to the relevant codes that state the court reporter's transcript is the official record. And AI-generated transcripts or deposition summaries are not impartial or appropriate.
All right, apologies, time is up.
Thank you. Perfect timing.
All right, this is the moderator. Next I have Stephanie Leslie, and Stephanie, you'll be given 3 minutes to speak with a 30-second warning. Please click the unmute me button when the prompt appears on your device.
Thank you for hearing me once again. I will make it very brief. I completely agree with Mary's comments as a firm owner as well. I would love to get some kind of clarity today, similar to the expedite issue, where I was basing all my dealings from here on out until maybe legislation happens. If there is any way that we can even, I realize there's so much background and research that needs to go into this and a lot of moving parts, but my question is, if we can get clarity as to whether the current code is referring to something that could be considered the AI summary. So if we are, because I've heard it said both ways in the discussion by the board, that it sounds like it's two separate things, but then there's also been reference to the fact that reporters are participating in some way. So if we can get some kind of maybe a motion today to clarify whether the definition is the same, if we would be potentially on the hook disciplinarily, if that's a word, for providing them, because like Mary, I am going to potentially lose out on business because my clients are now hearing, oh, we can get AI summaries from the firms. So, or if I call it something other than a deposition summary, would that be acceptable? So I would love just some clarity on that. And that would be my comment. Thank you very much.
Yeah.
Thank you, Ms. Leslie.
All right, this is the moderator. Next I have Dolores Renee Wood, and Dolores, you'll be given 3 minutes to speak and a 30-second warning. Please click the unmute me button when the prompt appears on your device.
Good afternoon, everyone, again. I just wanted to share that when I first saw this item on the agenda, I got really excited. I am newly retired from Riverside Superior Court. I retired November 1st, And I've been planning to open my own court reporting agency, and I've been doing a lot of research, and I've been in a lot of different business platforms. I am also a member of the ABA, and I see a lot of legal, legal laws and things that are happening right now as far as AI goes. One of my reasons for being so excited about it is because as I was doing my research, I noticed that there was almost no way I could compete with these other their law, their there are agencies that are owned by lawyers that have a court reporter, and they offer these deposition summaries to their clients, and they make so much money. I was shocked at how much money I found out they were making for these AI generated deposition summaries. And my question was, how in the world are they doing that? They're taking our work product and selling it. They're making a summary and selling it. How is that right? And as I kept looking, it was, they're attorneys, so they can make these summaries, correct? So I thought, well, how do I get to make these summaries? Because I'm going to lose a ton of business. There's no way I'm going to be able to survive this. So when I saw this on the agenda, I was super excited, and I started learning more about the remote depositions. I learned that if there's an agency owner that, is owned by a lawyer or whatever, that audio can even be put right into the system to create a transcript where they can make a deposition summary. And kind of like the other ladies were speaking about, on some of these remote platforms, they use ASR it's the automated sound recognition software. That's AI. We use AI all the time. We use AI when we're editing. We use AI, with the recognition software. And I'm pretty familiar with a lot of artificial intelligence platforms as well. And you can create them in such a way where there's certain prompts that you can create. And maybe if we had a regulation for prompts that are used for deposition summary, then that
30
would be
seconds.
appropriate. Thank you. If we had certain prompts that were regulated for a deposition summary, that could at least put us on the same playing field as the attorneys. I mean, the fact that they get to have a court reporting agency, that's not the same playing field as we have. So that's all I have to say right now. I'm running out of time.
All right.
Thank you.
Next, we have calling user 27 with area code 213. You'll be given 3 minutes to speak and a 30-second warning. You'll click *6 on your device to unmute.
Hello, good afternoon. My name is Shauna Gray I'm president of Los Angeles County Court Reporters Association. I just wanted to give a quick opinion on this where I think that, again, this is a case where reporters are observing certain duties to the consumer and agencies are not. The primary concern that I see on this issue is disclosure and privacy concerns for the parties that are involved in these depositions. And in depositions, hearings, and things like that, there's a lot of personal identifiable information that comes out on the record. People's birth dates, their social security numbers, the names of their children, what school their children attend. Medical records are discussed all the time in these depositions. And these agencies are feeding this information into their AI systems and spitting out these deposition summaries. And I don't think that the consumers are being told that this will happen. And I just think that this is an important protection for the consumers that the board should be concerned about. And that's what I wanted to say. Thank you very much.
Thank you.
All right, it appears that was our last request for public comment. Oh, actually, I apologize. We have a couple. We do have a couple requests from Mary Pierce in the Q&A. Would you like to let her speak again, or?
We'll allow for, yes. Thank you.
Okay.
Well, okay.
And then Mary, if you'd like to make another comment, I'll request to unmute your microphone. I would like to ask if people cannot use the Q&A for a chat box, as we're just using it to indicate if they would like to make comment.
Okay, my apologies.
No worries.
I thought that I was obviating the need to speak again, but I'll basically just reiterate the two comments that I did put in. That one, some agencies are selling them, some agencies are offering them as an incentivized come to our agency instead of the one you're using, you know, the one that's following all the current laws. Come over to us, we'll give you something free. And, you know, here's a nice margarita while you're here. And then also, yeah, you could, I would think that much that we have to offer all the same service to everyone, a generically produced AI summary could be offered to everyone that orders a certified copy. And customized ones, you guys can decide. I'm just asking that a decision be made quickly before the little mom and pop shops lose their business because we're unwilling to potentially violate statutes. And the big agencies aren't afraid of you. So I just, please do something, have some decision today that those of us who provide these won't be disciplined until something can be decided definitively and enforced. Just make it a level playing field, because I think I've already lost one client, and now I have a very large client, substantial portion of my business that's asking for this service. And I just want an equal playing field starting today. Please, I'm begging you. Thank you.
All right, this is the moderator. Appears there are no further requests for public comment.
Thank you, moderator. At this point, yes, Ms. Brewer.
So the public comment, thank you everybody who made public comments, by the way, and thank you to all the other board members. There have been a lot of additional issues raised in my mind, all of which argue against allowing this, not for allowing it, but I still think we don't have quite enough information, at least to decide that we would allow any form of it. I think perhaps we do have enough information to decide that we don't want to allow it. But as far as the licensed CSRs not being allowed to provide this, but the agencies are, well, the agencies are supposed to be licensed. If they're doing business in the state of California, they're supposed to be licensed or owned by somebody who's a licensee. So whatever the reporters are not allowed to do, they are not allowed to do. Now, I don't know about this exception for attorneys. I don't know anything about it. Never heard anything about that. I don't know anything about that. So that's number one. Number two, I did bring with me a flyer. I mean, this is no news to the people in the industry, but perhaps our non-licensee board members. This was part of a newsletter that I got, and it was announcing that these are available for a very good agency, a reputable agency, but they're providing them. So this is being provided like crazy.
Member, would you mind just sharing what that is?
So this is part of a newsletter that I got from Aptus Court Reporting. And apologies to Aptus, I don't mean to single you out. A lot of people are doing this. But it has, you know, they provided a bunch of information to their reporters or people they were sending it to in this newsletter. And then on this page, it has an announcement that said, I will read it aloud. Deposition summaries offered by Aptus. Aptus recently started offering law firms AI-generated deposition summaries upon request. These summaries are created post-production using AI software. Unlike a rough draft, AI summaries do not contain any testimony. Instead, they are a concise summary of the final transcript, calling out deposition highlights and key takeaways, which to me, those are two buzzwords for what we shouldn't be doing. That's Laura's personal comment on the side. Continuing, Technology has changed the method many summaries are created, but law firms and paralegals have been creating summaries from final transcripts for many years. Let us know if you'd like to see a sample or have any further questions. And I'm very sensitive to people asking us to make a decision. So my question of council is whether would we be within our rights, rights isn't the right word, but would we stand on good grounds to disallow this at this point based on what we have to go on? And I'm concerned because even though this says or assist, I'm looking at item B, 4B under this code section. It says or assist and continues in the preparation of a deposition summary. And at the start of all this, deposition summary is defined to mean information dictated by an attorney and reported or transcribed by a court reporter. So I'm no lawyer, but to me, it seems like this code section is confined to what the attorneys dictate. And I think this is a problem for all these reasons, these privacy concerns. It is absolutely weighing in deposition highlights and key takeaways, not a concise, let's see, what do they say? Does not contain any testimony, instead, concise summary of the final transcript. I just, I'm really uncomfortable with this. I really think they're inappropriate.
Ms. Sunkeith, do you want to hear from council first, or do you?
Oh, sure.
Okay. Council, can we turn to you?
Sure.
Okay.
Let me, not to sound like a lawyer, but what question?
What is my question?
Yes.
Okay, if we wanted to just say as a board, and I don't want to speak for my colleagues, but just say as a board, we come to a consensus or a decision that we would like to say this cannot be done. Licensees and licensed firms may not do this. Are we on good grounds? Can we do that?
So a couple things you've raised. One, the board has to always guard against what, I don't know how everyone's level of familiarity is on this, but what an underground regulation is. Underground regulation is essentially a policy that's universally enforced and applied in all circumstances, as issues come up. Essentially, it's a rule that isn't found anywhere. That's an underground regulation. We don't want to do that. So if what is proposed is to articulate a rule without a statute or a regulation to point to, that would be an underground regulation, and I would not recommend that we do that. If your question is on a case-by-case scenario, like perhaps if a complaint were to come in to enforcement staff about a particular situation, whether that fact pattern runs afoul of a particular regulation, enforcement staff would certainly pursue that on a case-by-case basis, and maybe it runs afoul of a particular regulation that is in existence and on the books, or maybe it doesn't, given the particular fact pattern. Those are two different situations. The latter you can do now. The former is not on good legal ground to do, if that helps.
To further clarify that question from Ms. Brewer, I think it would a motion to further clarify the existing regulations to make clear that deposition summary includes an AI-generated summary. Would that be? You think?
Ground regulation? Yes.
Okay.
What you would want to do to get at that issue is to pursue a regulation that clarifies an existing statute or regulation. For example, one option is to provide a definitional section or a definitional subdivision added to this regulation that clarifies some of the words that are in that regulation. For example, maybe the board would like to pursue a regulation that defines assist regulation. It would be an added subdivision. For purposes of subdivision B, the term assist includes but is not limited to, or includes da, 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 da. That's one of probably many ways you can get at this issue. I think it's perfectly legitimate for the board to come to a policy consensus on how they want to approach it. That's not an underground regulation. What is an underground regulation is once you've decided what that policy or that pursuit is, do it without any sort of authority, statute, or regulation and apply it uniformly.
Thank you,
That's the problem.
So, so to clarify, so a motion would be in order to direct staff to develop the regulatory language today.
Or another option could be a motion to direct staff to come up with options for the board to pursue this issue, and then the board chooses which of the options they like best, and then staff executes that.
Yes, Ms. Brewer.
Go ahead.
So if we decided to pursue a regulation, once we are pursuing that regulation, can we begin to operate in a way that enforces what would become the regulation?
No, because it's not on the books yet.
Okay.
And
So it
as
has to be on the books.
and as you may recall, part of the regulatory process, although I'll defer to Steve on this, is a very public and open process where you're hearing all sides and comments about whether this should be included. Oh, you left this out of the definition. And that's all part of the process, so that when it does have the force of law, which a regulation does, it has had that vetting, and a separate agency, the Office of Administrative Law, has also separately vetted this to make sure that it's legal.
Okay, so I'm sorry to follow up on this. I'm one of these people who I like to have things like very clear. But so if we are saying that this particular statute does not address this issue, which I kind of don't think it does, I'm sorry, because it defines deposition summary as something dictated by an attorney and transcribed by a court reporter, and that's not what we're talking about. So if we say that it doesn't apply, does that mean that licensed CSRs can be doing this and they're not covered by the statute? So in answer to these reporters who were saying, give us a level playing field, I think you have it. I think you have a level playing field. But you cannot take you cannot provide a deposition summary the way it's described or defined in the statute. And by the way, I hate saying that because I do not think this is a good practice. I do not think it is good for the consumer. I do not think it is good for the profession. And I think we ought to act forthwith to stop it. But as far as level playing field, you have it.
Thank you for that clarification, Ms. Brewer. I appreciate that. And I'll turn to council if there's any clarification on Ms. Brewer's statement. Okay, thank you. Mr. Dodgen.
And I think you summarized it perfectly, Member Brewer. I think you've kind of captured the feeling of this board or the opinion of this board. Also, though, we clarified, and just to set expectations for the folks that are listening in. Unfortunately, regulation takes 18 to 24 months. We are experiencing in real time technology moving faster than the pace of our ability to govern this. And so we're not happy with it, but but to your point, it is a level playing field. There are no regulations now. So I think, as we say, there's no action on this particular statute here, but we should pursue a different policy recommendation here to regulate these summaries going forward.
Yes, Ms. Sunke.
And maybe I'm just not sharp, but I've heard, please tell us, can we do it or can we not do it? And we need this urgently. What I have not heard is that we absolutely don't want to be able to do this, because we're assuming that I'm assuming, or at least this way this discussion started, I assumed we were being asked, or it was suggested, to prohibit this AI deposition summaries. And as we heard the discussion from the public, it sounded like it might be an opportunity. And I'm not saying without exploring it, I know we need to look into it more, but this might be an opportunity that firms of all sizes might want to use as another value-added service. So I'd like to know, I'd like clarification.
Mr. Dodgham? And then we'll do Mr. Dodgham, and then we'll go to Mr. Manayan. Thank you.
I think what we're saying, and we can confirm as a group, that we are saying there is no prohibition today, right? And everybody should know that there's no prohibition. So maybe I don't know if we need a motion or a vote on that, but we can say that. And then separate is, do we really think that these are good for the consumer or not? And so I think what we're proposing is options to explore to protect consumers, in the future from all of the concerns that Member Brewer brought up. About these potentially being biased and whatnot, and needs some regulation.
I'm with you. I also have the question of whether that's what's being asked. Well, that opens up the whole, and I know time is, but that opens up the question about public comment again, because that would require public comment.
I think.
But the urgency, I think, is addressed.
Right.
Mr. Manayan?
I think I think everyone here is in agreement on policy, but in terms of what legal advised, and correct me if I'm wrong, we cannot take a position on creating a regulation right now, because that will be underground regulation. What we can do is either, if there is a complaint before us, right, we can act on it. There isn't that in this moment. So I think if we want to take action, it has to be through actual regulation. So with that, I ask either maybe Ms. Fenner or someone from legal to help us come up with a motion that we can present forward so we can actually take a position on this.
And to clarify, Mr. Manayan, is the motion directing staff to provide options for
provide language
for regulation? Yes. Okay,
we don't need to come up with the language now, but a direction
to finish your discussion.
Right. And specifically, is that to disallow the use of or prohibit the use of AI generated deposition summaries?
I don't think that decision has been made by the board.
I believe that's the consensus here.
I'm asking if.
Yes,
I'm sorry, Mr. Manayan, could you say that once more?
Yes, that's the consensus among the board.
Motion?
So, yes.
Is there a second, or is there further board discussion?
The motion.
I'm sorry, Mr. Manayan, we're having a hard time hearing you. Would you mind repeating your motion once more?
Sure. I'd like to put forth a motion asking staff along with legal to put forth regulation to prohibit the generation of these AI summaries.
May I make an amendment?
Do we have a second on the motion first?
I'll second.
Yeah. Okay.
Okay. The motion's on the table now. So then we need to take public comment.
Well, can we take Mr. Dodgenham's possible amendment? I would like to get his take on it as well, and then that for public comment, because he might have more insight or a better motion that we can.
It may not even be necessary.
Okay.
It was just clarification.
Ms. Brewer has withdrawn her second, so if you're amenable, Mr. Okay.
And it was, I'm sorry, it may not even be necessary. It was just to clarify that we prohibit the generation of these summaries by CS court reporters or agencies by our group. So good.
Ms. Sunkeys.
I don't know that we want to go this route. I don't think we've got enough on this issue. I don't know that we've got enough information. Personally.
Okay, so our motion's not on the table yet. So Ms. Sunkees, I think a question to you is, what further information would be helpful in making this determination?
If a decision is made, I'd like input from the public on if they're asking that this be prohibited. If this is something that is able to be done by any firm, small or large, then I'd like to get information on
all of the questions you gave.
Exactly. We've raised a litany of questions that came up. So I don't think we've got enough information to move forward on asking for a regulation prohibiting it exclusively at this point.
Thank you, Ms. Sunkees. I would add, I appreciate the concerns raised in public comment regarding privacy in particular and data disclosure. And so I would suggest to add to that list of further research more information about like data retention policies, data usage. Other board discussion, and I apologize, Mr. Manayan, did you want to continue with your motion?
Doesn't seem like there's consensus among the board, so I'll remove the motion.
Okay, thank you. Is there further board discussion at this time? Yes.
Just a thought. I'm wondering, because we heard from the public the urgency of this, and we know the technology is moving so quickly, and we meet quarterly or whatnot. Is it possible we could draft some sort of motion that would request staff to explore this issue, and if necessary, to start to draft regulations so we could do two things by the next time we met? I don't know if that's ambitious.
I know you're trying to be efficient, but there actually is a process and there's a reason for the process.
Slow down on purpose.
Let me get the information that will inform your decision. But you guys need to make the decision. I don't make policy.
Sure.
So I can guess what you may or may not do, and I might recommend something. But ultimately, you guys are the policy body. So let me get the information. Let me bring it back to you. You guys have the full discussion with the input of the public, and then you can decide that. The urgency that I heard was the fear that they were going to be held to a different standard than the firms. And I think that board staff has been very clear from the very first time we got this question that we do not see it as a violation of the existing regulation.
Okay.
So if anybody has further questions with that, they can call me at the board office and I can elaborate, but I think I've been very, very clear. So that should take some of the pressure off needing to do something right now today.
Okay.
Ms. Brewer.
So that's all appreciated, and rushing usually isn't a good idea. But to me, there's an added urgency because I think there's potential harm to consumers. I mean, I really do. That's not made up. Right. And I hate the idea of seeing this stuff going on for a year and a half or 2 years till we can get something enacted. It's very frustrating because I don't think it's good. I don't think there's anything. Well, is there anything good from the consumer? There's nothing good to the consumer that they couldn't get independently from other means. I mean, yeah, they can use privacy data from other deponents, and that's not appropriate. They couldn't get that from other means. Anyway, I've said my piece.
Thank you, Ms. Brewer. And I want to build off of that and really second that urgency because there is a very immediate harm to the consumer. And my concern is that because, as we've said, the playing field is level at this time. My worry is that the proliferation of this technology will harm the consumer further, and then we'll try to get get everything back into Pandora's box, and the harm will have been done. So, I'll reiterate that urgency and maybe push for us to address this as early as possible at our earliest convenience.
I just was going to just say, I think that our industry is just one of many affected by AI, and we're having to deal with it just like everybody else is. But I think that urgency aside I think that we should take the time and do it well-reasoned.
Thank you, Ms. Sunkist. With that, any further comments from the board? Okay, seeing none. No public comment. Okay, let's. And I believe staff. Do we have what we need to move forward on that agenda item?
I've got the list of information that the board has requested, yes.
Thank you so much. We will move on to agenda item 14. That was 14. Sorry, 15. Future meeting dates. Per our usual custom, staff will poll board members offline about their availability for dates. Are there any public comments on this topic? Seeing none in the room, can we go to WebEx?
This is the moderator, and we are open for public comment on agenda item 15. If you would like to make a comment on this item, please click the raise hand icon or the Q&A icon down at the bottom. You may also raise your hand by pressing *3 on your device if you're an audio-only participant. All right, and it appears there are no requests for public comment.
Thank you, moderator. With that concludes the board's open meeting. We will be moving to closed session pursuant to Government Code 11126, Subdivision A1, to conduct the annual evaluation of our executive officer. The board will reconvene briefly after the closed session to adjourn. Thank you so much again to everyone who has been so engaged on so many of our issues.
All right, this is the moderator. I'm going to go ahead and put us into that practice session or that private.
Your microphones are off.
This concludes our meeting of the Court Reporters Board of California. It is 3:32 p.m. on November 15, 2024.